Good evening, good morning good afternoon in the States, good evening in Europe, and I guess good morning if you are in Australia, New Zealand, somewhere around there. And we have an interesting subject today because I was watching the closing arguments in the trial between New Hampshire and Brandon Castiglione. And I noticed something. And I thought I would, and especially after just a few hours of deliberations, they came back with the guilty verdict. And it reminded me of something, so I thought this is worthy of having a discussion around. But let's see here. Kayla is here. Hi. WV is here. Volkswagen, but the other way around. I don't know. Meat Popsicle. Billy Marie. MLS Law Show. Yeah. David. David should have a link. But I have another guest in the background here, but I thought I would be talking a bit. So we get a few more people in here. Oh, Meat Popsicle. Hey, Meat. Malcolm, how long did the jury deliberate? I think 3 hours, but that was including lunch, I think. I'm not entirely sure. Maybe David can tell me later. Gypsy Moon, there was no evidence that Brandon did it. That is one of the things that we will discuss today. Juni B. Jones is here. Good to see you. Oh, you just got the notification. I put this stream up this morning that I would have a stream, but you just got the notification. Yeah, I know the YouTube notification stuffy is not. Yeah. Malcolm. Good afternoon. Good afternoon. Teresa Meyer is it? Moyer. Sorry. Hi, Nikkei. Corn Pope, not Pop. Pope. Hi. I saw you yesterday on a stream where there was a discussion whether or not you, Oh, you were answering Malcolm. Wish I could say I was surprised. Yeah, it's been an interesting year so far regarding trials. And one of these things that we will discuss. First, a little bit of grifting, or, well, what do you call it? Let's see here. Getlawcards.com/Niklas. If you don't know what law cards are, these are law cards. These are your favorite law tubers and their highlights so far during trial streaming or other streams and stuff like that. I have a law card coming out, maybe not done just yet, but it should be in there. You have Jeff, you have Steve Gosney, you have Steph the Alternate, you have Joe, you have Aussie Overlord, you have a bunch of, and it's just trading cards, memorabilia, stuff like that. Just order it with the link I have up here right now. And other things is that if you want to support me via PayPal, I have a link in the description for you who doesn't want to give 30% to YouTube. Other than that, please be a member. I enjoy more and more having the members because that is a, what do you call it? a steady revenue, which I know will appear month after month, and which allows me to improve my stuff. Because, as you might know, I recently got a new PC computer. Well, it's a refurbished PC, and it's better than my old gear. That was a 5-year-old cheap gaming rig, which was giving up on me. So I hope I don't have to grift any more than this. If you want to send super chats, be my guest. But as always, if I would rather see you go there to Zachariah Anderson's Give, Send, Go. And yeah, much rather. And since last time we spoke, I think through my streams, another $150 has been donated to Zachariah Anderson's defense fund, which is great. Please continue. Tomorrow is sentencing, and I believe both Jeff and David will stream that. But enough grifting. Let's say hello to our first. I see John Gary is here. We will have an interesting, interesting discussion. I think you will have an interesting discussion in the chat. But let's welcome our guest here. Our first guest, you know her, you like her, I hope. Hello, Chandler.
Hey, Nicholas. Thank you so much for having me on today.
No worries. I like having you on. And I invited you to this about 20 minutes ago, and you found out about the subject.
It's a really good subject. I actually love this topic today. It's really pertinent to everything that's going on.
And the subject is, for you who haven't seen the thumbnail, it is guilty until proven innocent, the new standard. And the reason why I asked that question is, well, we have the Zachariah Anderson case, which most of us with some law education were gobsmacked. They came back first that fast, and second with a guilty verdict. And then today we had Brandon Castiglione, also amazingly fast return with a guilty verdict. And there are similarities between these two cases, which I noticed when in the defense. I first noticed it properly in the defense closing argument. I don't know if you've seen the Castiglione closing argument. So
no, I'm not familiar with the case.
Okay, a quick rundown of the man was shot in a house in the neck by in that room, or in the entrance to that room, when the sister and grandmother to the defendant arrived. He was on his hands and knees praying, and the cops came there. When within 2 minutes they led the defendant out in cuffs, and the defense have argued that since that, the prosecution and the cops have only searched for evidence to tie Brandon Castiglione to the murder. And you would imagine that Chavez is his name, the murdered. He was shot in the neck, close range. You would assume that would be murder 1. But the prosecution went with murder 2. And the reason, I believe David said it first, the reason was they knew the case was quite weak and very hard to have a murder 1 conviction. So they aimed for a murder 2 conviction. And for me, I don't care if it's, you can try for jaywalking, you still need the evidence.
Of course.
Yeah. So, well, let's just go into, I will only play, because the defense closing, I believe, summarizes it better than I can say. Let's see here. Share that. Ooh, damn. Boop. Where is it? There.
So this is a minister murder trial. Was it the victim who was a minister, or was it the accused?
Well, they call it the minister murder trial, Bible disputes turn deadly, but there is no evidence of a Bible dispute. And the minister, no, he wasn't a minister. He was just well with the Bible, and sometimes they had Bible studies, but he was not a minister. So there really isn't much in that headline that is correct.
Well, leave it up to law and crime to mislabel and sort of erroneously title something to make it more salacious. They do that all the time. The obsessed ex-boyfriend murder trial, that with Zach, that really was a problem. And of course they're doing it again here because they have to find something that's going to hook you, right? It's all about views and wine moms tuning in and getting really into all of the people who are getting convicted and being like, yeah, that we live in a just society, Gosh.
Yeah, it's clickbaity. And for instance, for you, me, David, and all the other, of course we have a certain aspect of clickbaity, but I do believe even if mine is clickbaity, that is still the subject. I wouldn't say it's now proven. Yeah, it's now proven that you're guilty. No, I'm just. Is that the new standard? But let's listen to the defense closing and see, because I do believe you listened to a bit of the Zachariah Anderson trial, so you probably will recognize a few things here.
You mean I watched the entire thing from start to finish? Yeah.
Yeah, a bit of it.
A bit, just a bit. I'll call it a bit. Just a little.
Yeah. So,
Brandon Castiglione is not guilty. The police jumped to conclusions.
Before, I was planning on doing a mock defense closing argument, but after listening to this, I have nothing to add. So, in my opinion, this is a good closing, but let's listen to it.
Within 2 minutes of the first officer arriving on the scene, Brandon was in handcuffs in the back of a police car. And because the police jumped to that conclusion, they did not do a thorough investigation.
Have you heard that before, Chandler?
Maybe once or twice in America, yeah. Sometimes the police just don't do a thorough investigation. It's, it happens occasionally.
Yeah. Occasionally.
And as you've heard, they only looked for evidence that pointed at Brandon. I want to talk to you about some of the ways the police did not do a thorough investigation. Evidence that they should have collected, but that they simply did not. So, what did you hear about that? Well, you heard there was a cell phone right there on Brandon's bed. See multiple pictures of it.
The law and C word stream is a bit choppy. So it's not me, it's law and C word.
But you heard the police didn't collect that. You heard Trooper O'Leary testify about the kinds of information that can be on a cell phone. GPS data, calls, texts, all kinds of things. You heard him explain how they go about the process of applying for a search warrant, what they have to show, that it's likely that there would be evidence related to the case. They had Brandon as their suspect. His GPS records of where he was that day, of course the judge would have signed off for that. The police could have had that. All they had to do was ask. But you heard, they didn't bother. It wasn't part of their application for a search warrant. You never heard that any officer ever asked Brandon for permission. You did hear that's another way to search for a phone, or to search a phone. In fact, that's what happened with Luis Garcia's phone. The police searched that because they had permission. They didn't ask Brandon for permission. They didn't ask for a search warrant. They didn't bother looking for the most basic thing.
Yeah, how about that? They have the suspect in cuffs within 2 minutes. They have him in jail. They have everything, but they never even applied to go through his phone.
Well, that's completely absurd. I'm trying to understand, was there a witness to this shooting that said he did it? I mean...
No, nothing. They claim...
Did he confess?
No, nothing.
Okay.
They found him praying in the doorway into the room that Chavez was killed. Chavez was in the home of the defendant.
Okay.
The defendant's father owned the home, but the defendant lived there. And he was found, he was doing painting. He was painting the rooms inside the home. And he was found dead inside one of the rooms. And they found the sister and the grandmother became worried at one point during the day that nobody was picking up the phone, so they went over there. The sister to the defendant went in, came out screaming. The grandmother went in and testified to seeing Brandon Castiglione on his hands and knees praying.
Did he explain why he was praying?
Nothing in testimony. There are, I have to check with David, but more or less, after the Miranda rights, he more or less clammed up. So
curious. This is a very odd case. I want to know a lot more, but I presume that the defense will have more to say.
Yeah, they have.
Was right there in front of them. Well, what other ways did the police not do a thorough investigation? Did the police not obtain important evidence and information that they should have? You heard when Mark Castiglione, Brandon's father, got on the stand and testified. He said he thought Brandon had a car that day, and then he wasn't sure, and maybe it was returned earlier, and he really didn't know. Why didn't the police find out back then whether Brandon had a car available? Whether Brandon could have gone for a drive? Whether Brandon could have gone anywhere? The police did nothing to investigate where Brandon was on October 1st.
It's not me stopping. It's law.
You didn't hear any police officer tell you that they knocked on all the doors on that street, that they asked, hey, did you see anyone come or go from number 15? I mean, we're talking about basic things that you should have heard. Where was any evidence of any of that? The police did not do the most basic things in investigating this case. They didn't do it because, again, within 2 minutes, they had decided it was Brandon. He was in handcuffs in a police car. Now, I've explained to you how the police jumped to conclusions. The government wants you to jump to that same conclusion. You heard in the government's opening statement them say how simple this case is. One bullet, one gun, one man. One man that they can't put in the house at the time of the shooting. One man that they can't say fired a gun that day. One man who had no reason to shoot his friend. What the government doesn't want you to think about is 4 very important words in this case. Beyond a reasonable doubt. You've heard that several times throughout the case.
Hey, dude.
Hey, David.
Hello. The world does not want me to stream today. That's all I have to say about that. But hello.
But
I'm
you're
glad-
here.
Yeah, I made it through all odds. I had to tape my mic stand back together just to get on top of everything that's going on.
Oh, I forgot to put my mic. I didn't even plug in my mic. Thank you for reminding me. I just have like the input on my laptop. Happy to see you.
Yes, you too. You too. Are we watching Closing?
Yeah.
Yeah,
this is
we are watching the defense.
Okay.
Yeah, we are watching the defense closing because I wanted to show Chandler similarities between this and the Sachs case because, well, we all have seen Sachs case and are quite familiar with the defense, how
Yes.
they closed. And there are so many similarities in shady or shoddy police work, assuming we already have the guy, so we don't have to investigate anything. But we haven't reached the part with the gun residue yet.
Okay.
Yeah. So, Chandler, David has watched the entirety of this trial, so he can fill you in better than I can.
Great, because I'm coming cold. I'm totally cold. I haven't seen any of it yet.
Oh, okay. I mean, I could give you sort of the 10,000-foot overview. The defendant is part of a Pentecostal church, very, very spiritual, we'll say. And they talk in tongues. He prays a lot in church. He prays down on his hands and knees and kind of talks in tongues for a bit. Testimony was there from his grandmother that he does that a lot in church. Other people have said he does it outside of church as well. His life kind of revolves around it. Now, what the jury didn't hear, but apparently is his background, is that he might have some drug issues, which kind of maybe pushed him into the church thing, and he's using that as kind of a substitute for his other addictions. But again, the jury doesn't hear that. All they hear is that on October 1st, 2019, one of the ministers, and he's not really like an ordained minister, he's an elder in the church, is helping out at his dad's house, at the defendant's dad's house, where the defendant also lives, painting and doing some repairs. At 7:30, the victim has a phone call with another minister that lasts about 30 minutes, and then no one ever hears from him again. For some reason, at like 2 p.m, everyone's panicking, and they do a welfare check at the house. And the defendant's sister goes into the house and sees the victim dead in the room with a single gunshot to the back of the head, and the defendant praying on his knees and talking in tongues. She runs out, then grandma runs in and sees kind of the same thing. And the bullet was a 9mm. The defendant had a gun. His gun is out in the hallway, but that's kind of understandable because they have all the furniture moved out and moved around and put in the middle of the room and stuff. They're painting, so stuff is moved around. So that's kind of understandable. The gun marking expert, the bullet marking expert, whatever, said on the record that matching the bullet in the victim to the gun was inconclusive. They have no blood whatsoever on the defendant except for his own blood from a scab on his back. And there's like no bloody shoe prints anywhere. The biggest thing they're hanging their hat on is one gun, one victim, one defendant, one house, doors locked. That's their whole argument. That's the state's whole argument. And interesting enough, the defense goes first with their closing. The state doesn't give a closing until after the defense goes. So you're watching the defense, and I don't know how much Nick is going to play, but the state goes after that, which was interesting.
That's weird. Why did they do it like that? That's not normal.
It's not normal. I looked up the court rules, and the court rule says it's up to the judge. It's up to the discretion of the court. So
yeah, I was
very
like, why are
weird.
we starting with defense? I got really confused. I was like, I guess the prosecution didn't have any, or maybe that part wasn't the part that Nick wanted to play.
There's a whole bunch of other stuff that's like outside the scope of this trial that gets really crazy, involving the victim's stepson, who then shot up a wedding 10 days later. And the wedding happened to be the wedding of the defendant's father. He was shot. The bride was shot.
What?
You know, there's all kinds of like other stuff outside of this trial.
Whoa!
And then
but I'm guessing that was not allowed.
Not admitted.
It's not
admitted.
admissible. Yeah.
The weird thing is so the sister of the defendant said that she had a dream about the defendant and was worried about him, and so that's kind of one of the reasons she showed up. But it's left ambiguous as to why she was so worried, and in the testimony, and we're speculating that was probably had something to do with his drug problems in the past and things. But there's this weird ambiguity hung over the whole thing as to why everyone's so concerned. Why are we doing a welfare check when this guy is essentially at work, painting a house from 8:30 a.m. until 2 p.m. Nobody's heard of him. He's working. Why are we doing welfare checks?
That is
so there's
odd.
a lot of ambiguity hanging over this trial. And for that, I think it should be reasonable doubt in my mind. But
I did a quick Google search and I noticed that there was something about like a grow operation at the house. Like the dad and the son were growing a lot of cannabis. And I feel like there's like a lot of similarity there between this and the Zach case, especially with the welfare check thing also. Like, is that your understanding that was a part of it?
I don't know about the marijuana grow being part of the welfare check. A lot of that was not brought into the trial. And
no, I just meant that those two things separately were two things that I just like that stuck out to me, like that were similar to the Zach case. I don't know if they included the grow stuff in this trial though.
No, not at all. No,
okay.
No.
All right, so different.
None of the drug stuff, none of the stepson stuff, none of any of the defendant's past was brought in, other than the fact that he goes to church like almost every day.
Well, I'm curious. I mean, I'm interested in the defense, but I really want to see what the prosecutor is like and what their closing is going to be. So maybe we should.
Okay, so here's one of the things though. So Friday, the state rested, and the defense wasn't really going to call anybody. Maybe they were going to call a police officer. They had a big conference at the bar at the judge's bench, and then there was a question that the judge posed to the defendant was, okay, so you think you're going to want to represent yourself going forward? We'll reconvene on Monday and figure that out. So then Monday morning, or this morning, they cut it all out. It's not in the feeds, but apparently the defendant said that the female defense attorney was possessed by the devil, and that's why he didn't want her representing him going forward. But apparently he withdrew his request. He sent a note to the judge asking that the attorneys be removed from his case. But apparently that was withdrawn this morning. All of that was cut from these feeds. You won't see it in the feeds, but my chat was following it in my Discord and were telling me all about it. But you can't get back to it. They've now edited the feed, so you don't see any of that. You just go straight into closing arguments now on Court TV and Law and Crime.
Wow, that's utterly bizarre. I'm wondering if this man is, I mean, I'm guessing he's fit to stand trial, but he just seems kind of
something's up.
Unusual, I would guess.
Yeah.
Maybe the stress and the pressure of the trial is causing some kind of delusional, or maybe he's just like that. That's very weird.
Yeah, there's a lot of weird stuff with this case. I just said everyone is acting weird in this case. Everything that they do is just weird. I don't know. It was
concluded. I was like ready to catch up. I thought that, we'd have I'd like settle in like with some snacks and stuff. And I was going to actually watch your coverage, and I didn't realize that the case was concluded already.
Yeah, I streamed day one because I thought it was interesting. We were watching in a Discord. I'm like, I'm going to stream day one. And then I just got busy. And then yesterday, I did a really long stream kind of going over day 2 and day 3. And then day 4 was essentially nothing. It was some crime scene stuff that said, yeah, there was blood around, but the defendant had no blood on him. and cell phone data. Oh, they didn't check the defendant's cell phone at all. They just went over the victim's cell phone. So no cell phone
Nicholas
data at all
mentioned
from the
that.
defendant. Yeah.
Weird.
And that was it. And then they closed. And so really short.
And how long did it take for them to come back with a verdict?
Less than 2 hours.
God.
2 hours 45 minutes. I read in the chat.
Oh, okay. 2 hours. Maybe just over 2 hours then.
Mm.
Probably a lunch in there somewhere.
Yeah, but let's continue playing.
The government has to prove their case. Brandon doesn't have to prove anything sitting there. The government has to prove that Brandon did what they're claiming he did. They have to prove that to you beyond a reasonable doubt. I want to talk about those 4 words for a minute. You know, your jury service started actually before you ever saw Judge Ruoff. Started with that video that you watched first thing when you came in on jury selection day. And that video introduced you to some important legal concepts, including different levels of proof for different kinds of cases. One level of proof is called proof by preponderance of the evidence. Think of it as the scales of justice, and if they tip ever so slightly one way or another, that's proof by preponderance of the evidence. That's all it takes in some kinds of cases. But that's not the standard that you're applying here. There's another, higher standard that applies to other kinds of cases. Certain kinds of cases have a higher standard called clear and convincing evidence. If the evidence is clear, if you are convinced, that is not the standard that you are applying.
No, that's this is Law and Seaward, and I saw there is a better one at Watch TV, but
proof beyond a reasonable doubt. And the judge has told you
then I have to look
if you
for
have
it,
a
find
reasonable
it,
doubt,
and put it up.
you must return a verdict of not guilty. And I want to talk to you for just a minute about why it's that way. It's that way because of our constitutions, both the New Hampshire Constitution and the US Constitution. And that standard was written into those documents. And the great scientist, statesman, founding father.
That's my tractor, Ben.
Said it far better than I ever could. So I'm going to read a quote from him.
We're avoiding copyright
He said
claims.
that it is better 100 guilty persons should escape than that one innocent person should suffer. Is a maxim that has been long
that's
and
one
generally
argument
approved.
you should never make.
That's why it's written into the constitutions, for this highest standard, proof beyond a reasonable doubt. I want to talk to you about another important moment in this case, one you may not be thinking of. On Tuesday of last week, not at jury selection, but right before the trial began, on Tuesday afternoon, each one of you stood in that box. Each one of you raised your right hand, and each one of you swore that you would follow the judge's instructions. You took that oath, and the judge has told you, if you have a reasonable doubt, you must find the defendant, Brandon, not guilty. Now, the judge will tell you that your verdict has to be unanimous, and that's certainly true. He'll also tell you that your verdict has to be your own individual vote. And I want to talk about what that means for just a moment, because you don't.
Okay, I'll go over to this instead.
Oh, 1 second. I'll be right back.
Gonna jump over to Ellen
Court
Seward.
TVs. Yeah. Oh, damn. I don't know how to move my... Well,
It's that way. It's that way because of our Constitution.
Yeah, they don't make it easy to switch
in the US.
streams real quick.
And that standard was written into those documents.
Yeah.
And the great scientist, statesman, founding father Ben Franklin
Okay, we
said
already
it,
heard
this
that.
highest standard, proof beyond of last week. Not at jury selection, but right before the trial began on Tuesday afternoon. Each one of you stood in that box. Each one of you raised your right hand. And each one of you swore that you would follow the judge's instructions. You took that oath. And the judge has told you, if you have a reasonable doubt.
Matt, my tractor, that's an aftermarket enclosed cabin, which is more or less, no, it won't, it will probably kill me faster than if it had no, this is just rain cover on my tractor. So, no, yeah. But then again, this tractor moves in an astounding 5 miles an hour downhill with the sun behind me. Yeah, so it's I think I can get away either way. But thank you. Yeah. And thank you, Corn Pope, for directing me to Court TV stuff. Now I have to invent a new banner, no, a new overlay so I can switch. Oh well.
I know I have
You
so
must
many
find
overlays.
the defendant, Brandon, not guilty. Now, the judge will tell you that your verdict has to be unanimous, and that's certainly true. He'll also tell you that your verdict has to be your own individual vote. And I want to talk about what that means for just a moment, because you don't all have to have the same doubt. If you doubt because the police didn't get the phone,
Does that make your case look weak?
because Brandon had no reason to kill Luis Garcia, if you doubt because the police didn't test the gunshot residue kit that they took, if you doubt for another reason, that's okay. You don't all have to have the same doubt. If each of you individually has a reasonable doubt, your individual vote is not guilty. And if each of you vote not guilty, that is what is meant by a unanimous verdict. I want to talk about some other ways that the police did not do a thorough investigation. And that, ladies and gentlemen, one of the ways is the gunshot residue that they took a kit for, that they collected.
Listen to this, Chandler.
You heard about the warrant for Brandon, for his body. You saw all these pictures, a couple dozen or more, documenting everything they did, documenting what he was wearing, documenting each layer of clothes they took off, documenting his hands. You heard. The police got a warrant for all of that because they knew it could contain important evidence. You heard they took swabbings of his hand for completing a gunshot residue kit. You heard that someone who fires a gun will have residue on their hands. The judge signed off on that warrant. The police requested that warrant. They did that for a reason. And then they didn't bother to test it. Could have shown that Brandon didn't.
They didn't test it.
They
They got a
didn't
warrant for all the swabs to do gunpowder and all these other swabs, gunpowder residue and stuff like that, and they didn't test any of it. They got the swabs, but they never tested it.
That sounds illegal. That sounds egregious. That sounds like it should be cause for a mistrial.
Well, I don't know if it's cause for a mistrial, but it definitely throws shade on their argument. Why would you get it and then not test for it? Unless you were concerned that maybe you did test for it, then you would come up with exculpatory evidence.
Well, think of the precedent that it sets. I mean, perhaps it's not cause for a mistrial, and maybe that's a bit of hyperbole on my part, but if people knew that, like, let's say that they were dubious about whether this guy really did it, all they had to do was collect it but not test it. I mean, that's such a dangerous precedent, don't you think?
I do. And one of my other things, I kind of said this when I was watching the verdict come in live on my Discord, is I don't think this necessarily is a bad prosecution. This isn't like a nefarious prosecution like you would see with Binger or some of the others. This is a bad investigation, but I think the underlying issue might be, what sort of resources do we have for people who are receiving public defendants? I have no idea what New Hampshire in this particular county's ability to get experts in to test stuff for public defendants, what the kind of expenses covered. So I'm purely speculating, and who knows? The experts might have been available, but why weren't they called? Why didn't the defense? These are public defenders. Why didn't they have access to the stuff and have it tested themselves?
Yeah, but
it
then
does
again,
sound like more ineptitude than than intentional misconduct. But anyway, sorry, go on. And also, sorry that I'm eating. I ordered delivery before I knew I was coming on stream, so I hope you guys don't mind. I'll mute myself.
No. But then again, should the defense, the chance that this is now, in my opinion, this is closing in on reversing the burden of proof. Because if the prosecution doesn't test it, why should the defense be required to? Because they certainly don't want to test it, because if they do, they might find he had residue. They don't want that to take that risk. And I had a discussion with a friend earlier today about unrelated. How much does the defense actually have to do after the Miranda rights are being read? And he said, absolutely nothing.
Yeah, that's true, because the burden is on the state.
Yeah, but this is one of why I had the thumbnail as I had. Are the defense taking more and more of a risk of not putting up a case in chief? As in this case, there was no case in chief for the defense. They don't test individually. They don't call experts. Is that becoming a huge risk to take against a weak prosecution? That a jury comes in with, well, he's accused, so the state must have something. Let's listen to what it is. And if the defense doesn't have anything other than the closing argument to disprove what the state put forward, have we then reached the guilty until innocent standard?
No, I think you're right. I take back my statement.
Well, I see here, he could have washed his... he could have washed his hands, but he couldn't have washed his clothes. They could have taken his... Oh, he might have changed clothes. Yeah, but look at in the laundry basket.
Yeah, they didn't talk about any of that. Nothing from the laundry, nothing from the sinks, nothing from the traps, the pee traps. There's no indication that he washed himself up. There's no blood on him.
Well, David, I have a question. If you don't think that he did it, then what's your alternate theory?
My ultimate theory is that this guy's kind of weird, and he stumbled across this and started praying. Literally started praying. And when the first day I started watching this, I said the defense needs to explain to this jury why what he did, meaning got down on his knees and started praying and talking in tongues, was appropriate. Because it sounds weird to me. But if you're in that church, if you're in that group, it's not necessarily weird. And so if the defense does a good job conveying that to the jury, I think we'll be fine. But that's really what I think happened. I think he stumbled across it, and that's his response.
I mean, how did he die though? Like, what if this guy didn't kill him, then who did?
The stepson. Who knows? I have no idea what the stepson, by the way, when he was on trial for the shooting up the wedding, attacked his attorney while they were having a meeting at the prison, and got charges on that, and then defended or represented himself in that case. This guy's a mess, the stepson. And so I wouldn't put it past him to have some sort of vendetta or something. But I have no idea. Honestly, who knows? It could have been just a random, killing, I guess. But the defendant's just kind of weird. And I feel like he got convicted because he's weird, not because the state overwhelmed you with the evidence.
Well, and he was in the wrong place at the wrong time, perhaps. I mean,
well, and he kind of, maybe he, did it to him, not did it to himself, but, when you show up on a crime scene, I'm thinking logically, I'm not touching a thing and I'm calling 911 and I'm checking my phone to make sure I was tracked, 6 different ways. He's not thinking that. He's thinking, I'm going to get down and pray because that's what I do.
I can see that. I mean, I understand. Like when I was, and before you came on, when Nick was explaining it, it sounded to me like it's possible that he's just a very religious, very spiritual person, and that if he came across something like that, it would cause him to fall to his knees and pray. I guess I'm curious, and I want to see more of the defense's closing. But from where I sit, it's reasonable to believe that if it was his house and he was there, and they don't have somebody else who is a more reasonable or likely culprit, it does kind of makes sense that he might have done it. And also if he was shot with a gun that like the bullet came from his gun, I mean, I see reason why he could have been convicted. It does seem like a logical conclusion.
I that's what I said too. I feel like my gut says it's not enough there to convict if I'm sitting on that jury, but I can also see how the jury might have come to a reasonable conclusion without leaping too far. Like when I say leaping too far, like the Zachariah Anderson was way too far of a leap to find him guilty. But this one, reasonableness could prevail. The last thing I'll say, and I might have to jump off here shortly. The state's argument is that he sat there, knelt, and prayed for 5 hours. That's their argument. And the reason why they give that timeline is nobody showed up until around 2:30 or so, something like that. And the last time the victim's phone was used, his first missed call was at 9:30 in the morning. So between 8:30 when he got off the call and 9:30 is when he was killed. And the defendant was there kneeling and praying over him for 5 hours. And that timeline doesn't make sense to me because they're basing it only off of, you put your phone down, you must be dead or murdering someone. That's their only basis for that timeline.
I see.
So,
yeah, there is something kind of off about that. I agree.
Yeah. But I mean, if the jury believes, okay, 5 years or 5 hours, that's a little too long.
Yeah, and there is no time of death, to my knowledge. They didn't know the body temperature because 5 hours, then they retrieve the body, get him to the morgue. If rigor mortis started to set in at the moment they brought him into the morgue, then you have a timeline. But there was nothing said about time of death. Not when rigor mortis set in, nothing of the sort. Did you hear anything? Not even the defense brought it up, which I found
didn't listen to the medical examiner, though, fully. I jumped around on the medical examiner, so maybe someone in the chat watched it all the way through and could probably better answer that. But I didn't hear anything.
And that would, if it was brought up, it should have been in closing as well.
Yeah.
No, state did not offer a time of death. So, nope. And that for me is, together with not testing for GSR, not testing for blood, not the bullet was inconclusive. The shell case was of the same type or the same manufacturer, more or less the same type. And the argument is that particular ammunition was rare because the expert said she had to look it up, or he, before. And he or she had been working in Miami and stuff and didn't recognize the ammunition. But that doesn't say anything if it's rare in New Hampshire. So nothing of the sort. But then again, neither did the defense. But then again, we go to the how much does the defense have to prove innocence?
I mean, the defense should be bringing something, in my opinion.
Yeah.
They brought nothing. They had no witnesses. They cross-examined fine. They did great on cross-examination, but they brought no witnesses whatsoever. We were talking about that, I think, on Sunday, that you should be bringing something, somebody, I guess, Was that
I forgot about
Baker?
that.
Oh, yeah,
from
the
the
fingers in the
Murdoch.
armpit. I
Yeah,
forgot.
the
Yeah.
Murdoch
All right, I got to jump off. I have my stream of my own starting in a few minutes. But you guys enjoy. Hopefully, I was able to offer something to the panel.
Yep.
But
Oh, definitely.
Yeah.
all right, take care,
Thank
everybody.
you for showing up.
All
Yep.
right.
Yep.
See you
See
around.
ya. Let's continue listening to this dude. The the legal vices light.
Yes.
Didn't fire a gun that day if they had just bothered to test them. But it wasn't just the gunshot residue kit from his hands that wasn't tested. It was also his clothes. All of those were collected. All of those were sent to the state lab. Those could have also been tested for gunshot residue. Again, could have shown if Brandon fired a gun. Could have proved that he did not fire a gun. The government didn't test that. The only evidence you heard about actually testing for gunshot residue, that was from Dr. Duvall on Luis Garcia's hands to eliminate the possibility of suicide.
Yeah, they tested the victim's hands to eliminate the possibility of self-ending, but he was shot in the neck.
Was it the neck or the back of the head? Because I heard both.
Back of
I'm
the
not
head.
sure.
Yeah,
Back of the head.
back of the head of sorts.
Right.
And that kind of eliminates self-ending. Now,
Right,
I've seen.
definitely. I don't think you would do. It doesn't seem comfortable to do that.
So while I'm painting this wall, let's try it. No,
No, it's illogical, certainly. So I'm not sure why, if they were going to do testing, why would they have to rule out suicide?
yeah, exactly. And while they were testing for GSR, why the victim's hands and not the defendant's?
It sounds sloppy and kind of badly done.
Yeah, and we already know it's him, so we don't have to test. That's the general rule of police work, in my opinion, in this case. Because I do, but then also, as David said, this is public defenders. We have no idea what their, how much money they have to go around to calling witnesses, calling experts, doing own testing. But then again, the defense shouldn't have that on them. Especially if, for me, listening to this case, I'm not near beyond reasonable doubts. I see in the chat some are, and of course, victim, defendant, possibly gun. Yeah, I see that it's not a giant leap of logic. It's him.
I'd say preponderance of the evidence. I would not say reasonable doubt, though, from what I'm seeing.
Yeah. If this would have been a not guilty verdict and then a civil suit, yeah, I could see that going through in a civil suit. But this is a criminal case, and just the fact that it shows second-degree murder, not first-degree, because shooting someone in the neck, you don't do that by accident. You don't do that without at least 5 seconds of I'm going to shoot him in the neck.
Well, true, but second-degree murder, the standard tends to be like, well, the first-degree murder would require evidence of, pre-planning, evidence of intent ahead of time. And so second-degree murder could be, a heat of the moment, spur of the moment, reactionary kind of murder. So I can see how if they don't have motive and they don't have proof of intent, that second-degree murder would be a logical conclusion to come to.
Mm.
But then again, the standard for intent is, I mean, if they don't have intent and they don't have motive, it's there is definitely wiggle room there.
Mm. Yep, that's. I think I can do this in 1.25.
I want to talk to you for a few moments about some things I think the government may try to argue to you. After I'm done talking to you here, they're going to get up, they're going to have the opportunity to talk to you too. I don't know exactly what they're going to say, but I have some guesses. And I want to talk about some things they're likely to say and why you shouldn't be persuaded by what they say. You know, at its simplest, the government wants you to believe that it must have been Brandon. He must have shot Luis Garcia, must have just stayed there and prayed for several hours. And you heard Luis didn't answer his phone after 9:30. You heard police got to the house around 2:30. We're talking about roughly 5 hours there. That's what the government wants you to believe. And one reason that they may try to tell you that you should believe that, they may try to say, well, Brandon didn't go many places. But think about what evidence you actually heard. You heard, again, from Mark Castiglione, Brandon's father. What did Mark tell you? Mark told you, I actually don't know Brandon's routine when I'm at work. I'm not there. I don't see it. I don't know what he does during the day. He did know that Brandon sometimes went to events at churches other than New England Pentecostal, that he had multiple churches that he was involved in, went to. Did Brandon go to some event at some other church that day? Did Brandon drive the car that Mark thought he may have still had that day? Mark certainly did not say that Brandon was home. You know, the government may also try to say, well, it must have been Brandon. The doors were locked. Who else could it have been? How could anyone else have gotten inside? So let's talk about that for a moment. You heard at least one other occasion Luis Garcia let someone into the house. You heard he had his wife Patty come over to see his painting.
That's a
so
bad
you know
argument.
At least one time Luis let someone in. He could have let someone else in that day. Mark said he wasn't aware of Luis ever letting anyone in. But that, again, he didn't know because he wasn't there. But you know it happened at least once. It certainly could have happened again. But here's the other thing about the doors being locked. It's not surprising if Brandon left, went somewhere, and came back, that he would lock the door behind him. He goes out, he comes back. He locks the door, he takes off his shoes, he's in his own house, and then sometime after that, he finds his friend shot, killed, and he starts praying. Government may try to convince you, well, must have been Brandon because he kept the gun locked up in his room in that file cabinet. Well, let's talk about what the evidence actually was. First of all, this is the file cabinet. You all saw it. There is the key sitting right on top of the file cabinet. Would not have been hard for anyone to pick that up and use that. And that's if the cabinet was even locked. Because what evidence did you actually hear? Again, you heard from Brandon's father, Mark. Mark said he wasn't sure if Brandon kept that cabinet locked. Mark said he wasn't sure if Brandon was still keeping the gun in its case in that cabinet. He didn't know. What you do know is that there's another place that gun could have been, and that is in a bag in the living room. You know it could have been there because you know guns were in that bag. The bag has a magazine. The bag has spent shell casings. Clearly, that bag was used to store or transport guns. That lock could have easily been in that bag where anyone could get to it. The government may argue to you, Well, Brandon didn't call 911. That's true. He didn't. There's no evidence of how long Brandon was there after finding Luis Garcia before the police arrived. You heard Brandon is a deeply, deeply religious man. You heard he often prays. You heard that's very common for him. You heard that when he prays, he shuts out the world. Ladies and gentlemen, it is not surprising that when he finds his friend killed, shot in the head in his own house, he comes back, finds that body. It's not surprising that for Brandon, what made the most sense was to pray. Certainly, would some other people have called 911? Yes, I think many would. But Brandon, what made sense to him was to pray. The fact that he did not call 911 does not make him a murderer.
No, but it does make him responsible for negligence.
One other thing.
I don't know.
Yeah.
I mean, it's negligent. If you find somebody who's who's been shot and you don't call 911, that is negligent and that could result in criminal charges. I think that's a very weak argument.
Yeah, I agree. That part is really weird. But then again, as I see it, until you find yourself in that situation where you find a recently killed person, you really don't know how you react. And
no, that's true. But
his
I mean,
reaction.
I don't know. Sorry, go ahead.
His reaction might have as well as been, I need to pray for his soul.
Right, but let's say, okay, he was shot in the back of the head, right? Like, he probably died immediately. But let's say that he didn't die immediately. Let's say that he was shot and he somehow survived being shot in the head. For the victim's family, knowing that there was a person who was there who could have rendered life-saving aid, who could have called 911 and chose not to, I would hold that person responsible.
Yeah.
That's a problem.
Yeah, I agree. Yeah. And I do believe that in the state closing, the way the bullet went from the back of the head or the neck and a bit of the jaw and then got lodged in the neck, they claim, this was not in evidence, that he probably survived, but the airway and blood flow was cut off completely. So he was dead in at most a matter of seconds.
Okay.
Mm-hmm.
That sounds
but I
brutal.
don't believe. Yeah. But that was in closing. I didn't listen to the medical examiner's testimony, but that was in the state's closing. The state did an excellent closing, I must say. But let's see what else he has to say here from the defense.
The government may point to try to prove their case is fingerprints. So let's talk about those for a minute. You heard there were 2 fingerprints found on Brandon's gun. Well, again, it's his gun. He owned it. It's not surprising that his prints would be on it. And you heard the fingerprint expert, Rachel Martinez, tell you she can't say anything about the age of those prints. She can't tell you when those were left on the gun. The only thing she can say is that those prints were left sometime after the gun was manufactured. That's all. Those prints could have been there for weeks, months, years. Those prints don't tell you anything about whether Brandon fired that gun that day. The judge at the start of this case gave you some instructions. One of the things he talked about was circumstantial evidence. And he described that. He talked about how, if it's dry outside when you go to sleep and it's wet outside when you wake up, that's circumstantial evidence that it rained overnight. It means no one saw it happen. That's what this case is, ladies and gentlemen. We have a purely circumstantial case. There's no evidence directly that Brandon shot anyone. There's some circumstances that the government wants you to believe indicate that he did. But the judge gave you one very specific, very important instruction that applies to circumstantial evidence cases. I want to get this right, so I'm reading directly from what the instruction was. And the judge told you that to be sufficient to establish guilt beyond a reasonable doubt, circumstantial evidence must exclude all other reasonable conclusions. This means that if, from the circumstantial evidence, it is reasonable to arrive at two conclusions, one consistent with guilt and one consistent with innocence, then you must choose the reasonable conclusion consistent with innocence.
Feel better, Nicola.
Again, that's the judge's instruction, the instruction that you swore that you would follow. There are multiple reasonable.
Yeah, he was found guilty on 2 counts of second-degree murder. One, the ordinary second degree, and the other one by negligence. I don't recall the exact wordings of the 2 counts. But it's not the first time I've heard about 2 counts of murder, more or less of the same sort. In the Letitia Starow case, she was found guilty of first-degree murder and first-degree murder of a person below the age of 12. And the sentence on both of it was combined, so it was no real difference. So I don't really know what the difference is for. Maybe Chandler knows that.
Well, I'm not sure what the 2 charges were in this case. So you said that one of them was something to do with negligence. I'm looking them up. I can't.
Well,
I can find what exactly the 2 charges are. I can probably explain the Starow one, but
let's see if I can.
So with Letitia Starow, with the differentiation, I mean, there are different ways that you can charge something like that. You can, I think that, I'm not sure if in Colorado you have the death penalty, but generally in death penalty cases, which occur in extreme examples, there are special, reservations made for charges like that kind of lean towards capital murder or capital crime, where the murder is particularly heinous or depraved, or it has certain substantial factors, and if there isn't the death penalty, then those might get separated into 2 charges because they can't really give her more than just life in prison. And so it's just kind of a way of enhancing the sentence because it is a capital crime. I'm not sure if in Letitia Starow's case there were actually capital charges against her or if those were just at the same level.
Yeah, I'm trying to find that. Maybe it says under here. Nope, doesn't.
I can't seem to find it. I mean, like you said, they chose to charge second-degree murder. They could have decided to charge him with first-degree murder. There's a lot of kind of leeway in how they decide to put the charges down, and it's strategic. It's what they think they can get, or what they want to get, basically. How the prosecution wants to punish this person, if they want to make an example of that person. Casey Anthony, for example, was charged with first-degree murder. That was a problem because they could not prove first-degree murder. They might have been able to charge her with manslaughter, and she might have been convicted of that, but due to the lack of extenuating evidence, they were not able to prove that. And so I think that it's intelligent of the prosecutors to to charge second-degree murder here. But I'd like to know about that other charge. I'm curious about that because you should. It feels like you should have one sentence for one crime, right? Like for one victim.
Yeah. And I'm not sure. Oh, I do believe in the end of Fridays when the state rested, they were talking about jury instructions about if they found Brandon guilty of second-degree murder, these 2 counts, they didn't have to consider lower, like 3rd or 4th, which also maybe the chat can fill me in on that, but okay, they read the charges in full during the verdict, so once you get there, you may know more. Yeah, let's play that after we are done here. We have 8 more minutes, which is 6 minutes in 1.25. So we can get there.
Conclusions based on the circumstantial evidence in this case. And one of those reasonable conclusions is that Brandon did not do it. It's reasonable to think that Brandon might have gone out that morning. Because of that, you must find Brandon not guilty. It's reasonable to think that maybe Garcia had someone over. And because that is reasonable, you must find Brandon not guilty. It's reasonable to think that the gun may have been left in that bag in the living room where anyone could have found it, picked it up, and used it. And because that's reasonable.
Yeah, and I think this is a mistake from the defense, because I believe I would have argued that since it was inconclusive for the bullet and the no fingerprint on the shell casing, I would have argued that they can't even prove it was his gun. But then in the state's closing, they are claiming it's a fact that it is Brandon's gun who killed.
That sounds like a profoundly missed opportunity, because he could have said, just because there was a weapon in the house does not mean that weapon was used in this commission of this crime. Somebody could have come in, they could have done the crime with a different kind of gun. The results were inconclusive. I agree. Missed opportunity.
Yeah, but I'm not entirely sure about the shell casing, because it was of the same brand as the bullet, as the ammunition in Brandon's gun. And it was an unusual brand. But then again, just because something is unusual, well, it's the number 10 most sold brands. It's very unusual. Yeah, but maybe it's number 2 sold from that gun store where he bought the gun. Because when we looked at here, we saw the receipt of the gun. It was a standard gun, standard Glock 19. With a standard, and that wasn't even discussed. Was it the standard magazine? Because if it is the standard magazine, it has 15 in the magazine, and you have one in the chamber. And the gun was found with 15 in the magazine and 1 in the chamber.
Oh, that's significant. So why would he reload?
Yeah, exactly. And even though this wasn't in evidence that he might or might not have had past with drugs or drug problems, but this guy, he's not clever. Let's just say that. Nothing in how he acts tells me, oh, he went to college and got a high degree and then went sideways. My impression of Mr. Castaglione is he's a moron. And if the family of the Castagliones are watching, that's my impression. But
I love how real those are.
Yeah,
but that's a really good point. You know, that's the most convincing piece of evidence I've heard so far, that they looked at the gun and the gun was fully loaded. That tells me that, you know, it would have to take a great deal of foresight and you know, thinking ahead and planning ahead, that I'm going to shoot this guy in the back of the head and then I'm going to put another bullet back in the gun so that they don't think it was me. That does take a degree of intelligence. It does take a degree of planning.
Yeah, and DM stated something different regarding bullets in the gun. Yeah, I know, but that was the testimony. They found the gun with 15 in the mag and 1 in the chamber. And for me, that is a real missed opportunity, even if it's debated between experts or not really clear. You argue that point, you hammer it.
I mean, it sounds like that came from a state's witness, because if the defense didn't put on a case, really,
Yeah.
if they didn't have,
Yeah.
witnesses, then, if that came from state, that there should have been significant cross-examination about that particular fact. I mean, I would like to see that.
Yeah, but let's play the last thing here, and then, just for argument's sake, you have heard about the stepson of the deceased, and yeah.
You must find Brandon not guilty. Now, I want to talk to you for a few minutes about that gun. You heard about how this was tested. You heard
It's possible to leave a bullet in the chamber while loading a magazine, right? Yeah, but if it was found with 50, yeah, of course he could have shot. A new bullet would have been loaded into the chamber, and then he could have picked out the magazine and put another one in. But that is quite high level of planning, and the state is saying second degree. So it doesn't add up for me. Yeah, and I see John Gary's. Yeah, yeah. No, first of all, he wasn't next to a victim. He was praying in the doorway to the room where the victim was found. Shot with a single round from his gun, debatable. With his print on it, it was his gun. He didn't call 911. We don't know how we react when we find a recently deceased person, or definitely not a recently shot person. There's a lot of... I understand you. This is a case of Colonel Mustard in the library with the candlestick. But that's a child's game. Cluedo. This is a trial. I need more than that. But John, I sincerely hope that you will return to my streams and my chat. I love being challenged, because that means I have to rise my arguments to either rebuke, or maybe even at some point, yeah, he's right. Not this time, but I love it when people disagree with me.
about what information the lab had when they tested this. Now, you heard from Jill Terrio, the firearms expert. She talked to you about a training she went to about cognitive bias and how that can be unconscious, how that can, having information about a case, can unconsciously bias or taint, influence conclusions that are drawn. She said that's especially important in fingerprint cases.
This is a good argument. Shooting the gun previously, then reloaded with a new mag. Yeah, but there are no other magazines in evidence. There's no evidence that he had more than one magazine.
Right. If he had to reload, I mean, I don't think I've ever seen a murder case where somebody has shot a gun and then they decided to put a bullet back in the gun, you know, to reload the gun to make it look like that gun hadn't been shot. I mean, that, not only is it nonsensical, but I mean, you can prove in other ways. You can prove the gun had recently been fired. You can prove that, you know, that there might be gunshot residue on you or on the victim. So just putting, you know, reloading the magazine doesn't make sense.
The gun was found on the bookshelf in the hall. Yeah. Gun was found on the bookshelf. Well, not exactly a bookshelf. Since they were repainting the rooms, everything, a lot of stuff in Brandon's room was moved to the hallway. And on top of a shelf of sorts, there was the gun was placed. And so he supposedly shoots the victim, puts gun on bookshelf in hallway, and goes back to doorway and pray. I guess that's the prosecution's argument.
And possibly changes his
Bra-
clothes. I mean, they didn't find any clothing that had any blood spatter on it.
They didn't look for any. They took him in. They took nothing else from the house.
This is a
They
very
didn't test
weird case. Very,
Yeah,
very weird.
I agree with David. Everything in this case is weird because you have Brandon at home. You have a guy there painting. All our friends, everybody is a part of the Yodeling Christian Church, whatever, Pentecostal, whatever they're called, speaking in tongues and stuff. And they start calling. He doesn't answer at 9:30. Then they keep calling because they are worried. Why?
There was never any explanation of that. I mean, I could see maybe saying like he was supposed to call me at this time and then he didn't, or I was expecting an answer from him about something important, or he was supposed to do something like a financial transaction on his phone and there was no evidence of it. But no explanation.
No explanation. Why? Because the sister was worried of Brandon. The grandmother was worried. They went over there and they couldn't get in. Even though through testimony we heard that he had a spare key under the doormats. But if you're the sister and the grandmother trying to get in, how do you not know there's a spare key under the doormats?
Well, did they live there? They were residents of the house?
No, not grandmother, not sister. They had moved out, I believe. But at some point, they were in the house at least twice a week for Bible studies and going to church and stuff.
Okay. I mean, I can see if they were not residents of the house that they would not have known that there was a key there.
Yeah, but I don't know. In my family, if someone has a spare key, everybody knows where it is.
Even the people who don't live at the house, like people who are just in your family.
Well, no, family. If I need to get, for instance, my mom and dad goes to Portugal over the winter because they hate cold, and we know where the spare key is because water the plants and stuff like that.
Right. Okay, that does make sense. I mean, it's logical to think that they probably would know where the spare key would be, and if they were there frequently, then maybe. But if they went over for Bible study, I presume somebody would be there to let them in.
The spare key was only there for Garcia while he was working there. It was not normally left there per father's testimony. Okay. Thank you, John, for clarifying that.
I feel like this case has very little information. I feel like we're missing a lot of information, and I'm going to bet that the fact that this guy pled the fifth, that he didn't, he just clammed up and refused to speak, makes him look guilty, and I'm sure that was used against him at this trial in a lot of ways.
I don't I'm not sure, but it might have been implied, but never outspoken, that he clammed up, because nothing I have seen so far says there were any police interviews. Just there were police testimony, but nothing about we tried to interview Mr. Castiglione. But maybe since he clammed up and lawyered up, there was nothing to show. I don't know. Right.
Well, I mean, if he did, then he could have had many reasons for doing that. But generally speaking, somebody will look at that and they'll go, "Oh, he lawyered up right away. That means that he's guilty because he didn't want to talk, because if he had spoken, if he hadn't asked for a lawyer, then they would have had a lot of evidence." But the Fifth Amendment is a really important privilege. So
He may not be that dumb because he was smart enough to not talk to police. Well, there's a slight difference, because you have that Dunning-Kruger effect where people are slightly more stupid than the average person. But if you go below that, they don't have that. And these people who think with the Dunning-Kruger effect, with people who are slightly less smart than the average person, they talk. Because for some reason, they think, even though they are slightly below average, this is my theory at least, that they know something is slightly different, but they think that, oh, that must mean that I'm smarter than everyone else. Well, no, you're not. So they
I
try to
mean,
talk.
a lot of people.
Yeah.
Sorry. A lot of people talk to the police. I mean, Alec Baldwin wouldn't shut up when he was talking to the police. You know, there are a lot of people who like they feel like they have to talk to the police. They actually don't understand that they have the privilege to have them. I mean, because at this point, you know, the Miranda rights, when you read them, you have the right to remain silent. Anything may be used against you. You have the right to an attorney. When people hear that, they've been hearing it for so many years on TV that they don't really hear the words and they don't think, well, I have a right to an attorney, so I don't necessarily need to talk in this interview. They kind of hear that and they might gloss over that. There are a lot of very, you know, afraid, intimidated people, and especially with American police, like American police are very manipulative. So people talk, whether they're smart or dumb. Lots of people talk. Lots of people don't really understand that right or utilize that right.
Yeah, okay. John Gary, they didn't use his silence against him, but his lack of any explanation probably helped convince the jury. Yeah, and then we go back to the defense shouldn't have to refute anything. They should just point that they didn't check that, they didn't check that, reasonable doubt. Should.
It sounds like defense didn't utilize a lot of things that were available to them that could have helped.
Yeah, I have that exact same thought, actually. There's a difference between jury inferring guilt from silence and the state case being stronger because there is nothing to... I
agree.
Yeah, that's actually a good point.
I would say that, you know, let's say that he was praying in the doorway, you know, and he had just said, oh, I was praying because I came home and I saw him and he was dead. And that's what I do. I would, you know, I was so shocked and I immediately felt the need to drop to my knees and pray to God. That's a simple, easy explanation. If he had just said that, you know, maybe it would have been unbelievable, but it would have been something. And so with the lack of explanation, you know, he could have said, like, I saw somebody going out the back door and then I saw that he was, you know, there was blood everywhere. Like, I agree with John. I think that is a good point. There is a difference. And I think that the jury probably, you know, in lieu of another explanation, if I were on this jury, I might have voted to convict this man. I mean, it looks like he did it. Just saying.
Yeah. Lack of defense outweighed the lack of evidence. Yeah, it might be. Because there was... I was watching David's stream and I had it on in the background while working, and I do believe he on several occasions said, object to that, why doesn't that was a decent cross-examination, but why didn't they point this out and stuff like that? Or it might... Just speculation. They might have known. Maybe he confessed to them, and that's why they didn't put up a defense. I don't know. I have no idea. But there's still the absolute lack of evidence and the police misconduct in... They had his clothes and everything on him, including himself, was swabbed, but never tested. And
yeah, that definitely sounds like shoddy police work. I mean, it sounds like there were just a lot of balls dropped here from the defense, from the police, from everybody.
And even if someone disagrees with 15 in the mag and 1 in the chamber, yeah, but you still argue it. And
that's the problem. If I may summarize, I think that the conclusion that I'm coming to here, from everything that I've seen, there is a lack of alternate explanation in this case. The problem that we have is that everybody in a situation like Mr. Castiglione deserves a proper defense. They deserve they deserve all witnesses to come forward. They deserve for their defense team to put everything that they possibly have, even if it's weak, and especially for all of the facts to be explored carefully and thoroughly. And there was not a careful and thorough explanation or exploration of the facts here. And without all of that, you can't really have a proper defense, can you? I don't know. What do you think?
Yeah. And John Gary makes another good point. This was New Hampshire, but Wisconsin jury instructions say, while it is your duty to give the defendant the benefit of every reasonable doubt, You are not to search for doubt. And if the defense doesn't point out, at least you can be general, in my opinion, about a lot of things. But if there are stuff that you know, this I need to hammer. You need, I believe in the power of three. 3 good arguments. And you hammer those. You can generalize, but 3 good arguments. And those needs to be hammered. And I don't know what, but that's just by pure experience, by writing a few articles and reading and ghostwriting and stuff like that. The power of 3 is really powerful. If you have 3 good arguments, hammer them. Like the gun, the no testing of his clothes, no testing of his phone. Hammer it. For the last 30 minutes, we have moved 2 minutes of his defense closing.
Maybe we should
Talk to
finish
you
this then.
about a study that she had heard about where fingerprint examiners were given 2 sets of prints to compare. And then a few weeks later, the same examiner was given the same sets of prints, but given different information about the case, and how that often led them to make a different conclusion. Either that something was a match when they previously thought it wasn't, or vice versa. And what did you hear from the actual fingerprint examiner here? Rachel Martinez told you she knew Brandon was a suspect. She knew the gun was found in close proximity to him. That is information she should not have had, information that influenced her conclusions. But it's not just that information that was given to her. You heard more than that. You heard how she had conversations with the lead investigator in this case, Trooper Stephen Sloper.
Maybe I should do a
Now,
mock
Trooper
defense closing
Sloper
of this.
said
I don't know.
that she was to look for evidence that would connect that gun to Brandon. And Trooper Sloper told her, if you find a connection, don't run any other tests. He specifically told her not to have those 6 swabs that were taken from the gun. 6 swabs of touch DNA. He said, don't test those. Ladies and gentlemen, the government wants you to convict Brandon without ever hearing from the lead investigator. Why didn't the government call their lead investigator? Well, you heard that too. The lead investigator, Sloper, said he was checking with the Attorney General's office and would get back and let the lab know what to test and what not to test. The very office that is prosecuting Brandon made the decisions not to test evidence that could have proven Brandon did not do it.
Objection, Your Honor. That's not evidence. Well, the jury's recollection of the facts will control. Very well. Thank you.
That's why you didn't hear from Stephen Sloper. And just to talk about that just a little bit more, you heard there were 6 swabs. 6 swabs that could have each had touch DNA taken from the grip, and there were swabs taken from the trigger itself. That evidence was not tested because prosecutors didn't want it tested because it could have hurt their case. I want to talk to you about one other very important thing in this case. Something that, quite frankly, makes absolutely no sense whatsoever. You heard testimony from Trooper O'Leary. He was the trooper in charge of actually physically collecting the evidence. You heard a lot of exhibits were labeled JGO 1, JGO 2, JGO 75, whatever the numbers were. And that JGO, those were his initials. Now, what did Trooper O'Leary tell you about the gun? Trooper O'Leary told you that he collected that gun, and he told you how many bullets were in it. And he even has it in writing. He testified to it. He has it in writing, State's Exhibit 114, I'm going to ask that you take a close look at this when you're back in the jury room, talking, deliberating about this case. Because what does this say? It says that there was 1 round in the chamber,
I missed this
15
part.
bullets in the magazine. Ladies and gentlemen, you heard from Jill Terrio. The magazine had a capacity of 15 bullets. So I guess the government wants you to believe that Brandon, sometime before 9:30, shot his friend for no reason, went to the other room, loaded 1 more bullet into the gun, then put the gun on those plastic shelves in the hallway, then went back into the room where Luis Garcia's body was.
He shouldn't have hammered it this way.
No?
He just say that it was fully loaded. 1 round in the chamber. The gun was not used.
That does sound succinct, yes.
Yeah, you have not giving the explanation for the state. The state wants you to believe that. Shut it. Serious. No, you don't need to explain it. Hammer it.
Good point.
And then pray. That makes no sense whatsoever. That is a huge reason to doubt the government's case. Why on earth would anyone do that?
And he doubles down on it, giving them, well, it could be done if he really wanted. Well, it could be done. That's why he's shutting up. It could be done this way. Thank you, defense attorney, for giving me an explanation.
I see what you mean. Yeah. He has to present his narrative of what really happened. The gun was never used. Yeah, some problems with this. You know,
Brandon
Jeff.
could have gone anywhere that morning. That is a reason to doubt. There is no physical evidence that Brandon fired a gun that day. That is a reason to doubt. Brandon had no reason to shoot his friend. That is a reason to doubt. There are many, many reasons to doubt the government's case. The government did not prove its case because it could not prove something that did not happen. Brandon Castiglione did not shoot Luis Garcia. Brandon is not guilty.
So that was the defense closing. I listened to it earlier today, but thanks to the chat and my pronunciation of the word chat. I do believe there are a few mistakes in the defense. Yes, he has to, since he's starting with his closing, he has to try to argue against the state, since he doesn't get a rebuttal. He doesn't know what the state would. Yeah. But
That's so weird. I have never seen that happen before. It always goes the other way.
Yeah. Generally, even the state getting a rebuttal to the defense closing, I think is wrong. But that's just me. Because
it feels
the
wrong.
state, yeah. But you heard a little bit about the stepson who was shooting up the wedding a few weeks later after this. So So this is one of the things I really wish that the fans would have called this guy. That's the stepson of the killed person.
That's a lot of tattoos. So, okay, wait. So his crime was what now? He shot up a wedding?
Yeah, 3 weeks
Shoots up a
after.
wedding?
Yeah.
Who does that?
3 weeks later, he shut up the wedding. Brandon's father got married 3 weeks later. And he went there and started shooting. Now, could it have been, you killed my stepdad, so now I'm going to shoot everything? I don't really care. If I had a chance to call him as a witness, I would have taken it. I would have put him on the stand. So, you are known for trying to kill people.
That is really strange. I don't understand why they didn't investigate him.
Well,
I mean,
Nanya
did
said,
they look into
yes,
him?
of course.
Did he have an alibi?
Yeah, but they didn't check anything. And yes, of course, I also believe it was retaliation. But as a defense, yeah.
This case seems like it has so many errors.
Yeah, this case is weird from beginning to end. It's so much weird. The shoddy police investigation, having the swabs and not testing it because the lead investigator called the prosecution's office who told him, do not test it.
Yeah, that is peculiar. I don't understand it. I mean, you see it. You see it everywhere. It's not like everybody does the best job or like they're thorough with every investigation. And some of it is, clerical error. Some of it is like people are overworked and, they get these backlogs of things. But still, the point is that it's problematic for the person who is accused. The person who's accused deserves to have everything investigated properly.
Yeah.
Without there's not enough justice. There is not clear, evident justice.
Yeah, and as I've seen in the chat all this time, why didn't the defense put up a case? Why didn't the defense ask this? Why no expert? And for me, yeah, I understand. I don't understand why they didn't do it. But then again, they shouldn't have to, because the second the arresting officer says you have the right to remain silent, that's it. You shouldn't be able to. 100% of evidence of guilt should come through the prosecution's office. And this is something, I don't know if it's more recognized now since people are starting to stream trials, that, this is odd. But how long has this been going on? Since streaming trials isn't that old. Is this a new thing, or has it been going on for 5, 10, 15 years? That, they are prosecuting him. They went through a grand jury. He must have done something, otherwise he wouldn't be here. Why doesn't he bring on a case? Why doesn't he prove his innocence? So have we already passed because this is New Hampshire. Zachariah Anderson was in Wisconsin. If it's going on in 2 states, how many other states is this happening in? So have we already passed the point of guilty unless innocent unless proven guilty? Or are we already in guilty until proven innocent if you don't put up a defense case? Do you
I think a lot of people feel that way.
Yeah. And I saw that I forgot to mark it with education in civics. And we don't have any civics education in Sweden whatsoever, so I can't be an advocate for that. But we don't have a jury as in the United States. So we don't really have that issue. Now we have to a bit of interesting court cases, but not at the level as I've seen here in such a short amount of time. So that's
right, and imagine all the cases that we don't see. I mean, this is, we have a spotlight on this because we have cameras in the courtroom. Why are there cameras in the courtroom? Because this case happens to be interesting to the public, or somebody granted that. Think about all of the cases in which maybe they request cameras but they're denied, or nobody requests cameras at all. Could we learn something from those cases? The fact that we're not seeing it, it's like, like with police body camera footage, like it shines a spotlight, and I think it'll either act like it'll either get people in the court, like the prosecutors, etc., to act differently because they know that they're on camera. Maybe they'll be on their best behavior, maybe they'll be trying the case a little bit better, or maybe they won't. But I think it's really a good question. How long has this been going on? And, you have to ask a trial attorney. You have to ask somebody who's been working as a trial attorney in these kinds of courtrooms for, decades. They'll have the answer to that question. And that's I think Steve Gosney, for example, he said, I have no faith in the justice system because he's been watching, he's been doing that for decades. So, is justice in America dead? Quite possibly. Has it been dead for a long time? Yes, also quite possibly. I don't have the answer because I'm not a trial attorney. I'm not even an attorney, but attorneys have been saying this. And so I do believe them.
So, but let's see here. Tomorrow is Zachariah Anderson's sentencing. And yes. I know David will stream it and Jeff will stream it. I will be on with David, I think. I'm having the day off tomorrow and maybe not so much work on Wednesday. So hopefully I can put out some more stuff. But I think we should finish off by watching Zachariah Anderson's defense closing, because this is a few months ago. Maybe not everybody in the chat has seen it, but just to make a comparison of police work. So, well, you all recognize that dude. So
I actually have to go, but I will be watching. Thank you so much for having me on.
Yeah, no worries. Thank you so much for being on. It's been a really interesting discussion. Everything gets more interesting with discussion.
Absolutely. And this is one of my favorite defense closings. So I hope everybody enjoys it. It's too bad that it didn't go the distance. But I do think that Zach had an incredible defense team. It's a shame that what happened. I'll see you around, Nick.
See you around.
Bye.
Bye. So it's just you and me, chat. So let's watch the Zachariah Anderson's defense case. Defense.
Good morning, ladies and gentlemen. I just want to echo what Mr. Gravely said earlier, because we do share the sentiment that you've given us your time. You've taken time out of your lives. You've gone much further than we thought we were going to take in this case, and you've been incredibly patient. And it's a very important thing when we're talking about how jury trials function in our society and why they are so very important. And I know that all of you take your duty very seriously and have steadfastly taken an oath to do your duty properly. In our country, of course, it's part of our system that we don't leave it up to a prosecutorial agency or any one individual or even just law enforcement collectively to determine whether or not somebody is guilty of a charged offense. We bring in people from the community that have no bias, have no predisposed opinion about what the outcome should be, and we ask you to listen to testimony and examine documents because you are the finders of fact. What the judge did yesterday before we took the break was that he read jury instructions to you. Now, just so you know, you'll get a copy of those jury instructions because I know it's kind of hard to listen for half an hour to all that legal stuff. But that's really basically the structure, the outline, and how the trial is supposed to work, giving you some guidance on what the law says. But there's nothing in those instructions that tells you what facts you are to find. And that's why you're here, is to focus on facts. You'll also notice right before we started, the judge said no taking of notes during closing arguments. That's because what Mr. Gravely says and what I say is not evidence. The evidence part of this case has already happened. There's a theory that what the lawyers say in closing argument shouldn't even matter.
Oh, before I... Oops. It was my father's birthday today. Just now telling you out of the blue. And he turned an even number. So very much congratulations to my father for being alive for so long. I hope he keeps going. But he reminded me that on my birthday a couple of weeks ago, he gave me a whiskey that he wanted me to try because he found it, and he says, this is great. Yeah, so happy birthday to Papa Starow. But the whiskey he gave me was this one, Golden Lock. It's a blended Scotch whiskey. Now, me and my dad, we have always given whiskey to each other, but it's always like Lagavulin or Anknock or something in that range. So, but he decided to give me a $7 whiskey. Okay. Thanks, Dad. But he said, I have to try it because it's actually good. So let's open this baby up. What the actual F is going on here? Oh, it has one of these corks. Motherfucker. Dad, you ass. Gone. Why do... Jesus Christ. Everybody should have a pocket knife close at hand. Yeah, I will be testing this, but for tomorrow's I might chug it. Papa being snore. Bartender style. I know how to pour a damn whiskey. So smells like a blended whiskey. Cheers. It's a blended whiskey. I had worse. For a $7 blended whiskey, it's good. But compared to the stuff I normally have, no. Yeah, Papa being snorky. Yeah, happy birthday, Papa. I will tell you here. I will tell him you said happy birthday, and yeah. So I tried it for a $7 whiskey. It's good. Mine is a bit much better. I can't promote alcohol. I'm living in a country where we have an alcohol monopoly. Yeah, stuff that makes you go high. As long as it gets the job done. So, yeah, that might be good for tomorrow actually, because as I've seen a few of you in the chat going on, I doubt that Judge what's his face, will go for anything other than life without parole. It's but almost the harsher the punishment, maybe that can be an argument in the 500,000. Mats is talking about allegedly moonshine, and yes, Sweden has a very, very interesting. They try to almost like in the United States abolish the alcohol. Boo! In the 50s, 60s, 50s, something like that. Boy, it was a mistake. But the only thing it resulted in was that people started to make their own alcohol. And in my neck of the woods, where I grew up, there might have been one or two distilleries in the woods up there. Did you watch the Eurovision Song? Has there been a Eurovision Song Contest again? No, didn't see it. Who won? (1920s). No, we didn't learn from the United States, so we did it in Sweden in the 50s instead. Yeah. But let's continue with this.
Because we're not presenting facts to you. That's already happened. Now, I obviously take my obligation to represent Mr. Anderson.
Oh, we won the
fully,
Eurovision.
completely, and with the
Yay.
amount of attention that he deserves. So I am going to make some comments here. But I want to focus first on the fact that we are here to discuss what the evidence is. We just heard a 95-minute speech about what Mr. Gravely thinks the evidence shows. It was layer upon layer of conjecture. He used the words, maybe this happened, or I propose to you, or I suggest.
I need something good to wash that
That's
down
what
with.
argument is. It's really putting a spin on the facts. But the most important thing, and as you paid attention over the course of the past 3 weeks and a couple days, when you took notes and you paid attention, you are the finders of fact. Now, very soon, extremely soon, you're going to get to go back into that deliberation room and finally start this process of talking about the case. At the end of every day and during every break, the judge has told you, please don't talk about the case. And I know you've been dying to. As the developments have occurred and as the testimonies come in, it gives you an impression. Certain facts will stand out to you. Certain other things will catch your attention, and you wrote those down. Then that is your opportunity when you finally go into deliberations to compare notes.
We are
and
almost
to
at
debate
2 hours, so I
what the
can
facts of this case
talk
are.
freely.
But we're urging you at the outset, let's focus on facts, not guesswork, not theories or anything else. Now, Mr. Gravely's right. He concluded with the fact that the burden of proof remains at this table at all times for each and every element of all the offenses charged. It never shifts to the defense. And some of his comments actually did talk about, why didn't the defendant do this? Why didn't the defendant do that? It's the state's obligation to present all of the evidence, both the burden of production and the burden of persuasion. In fact, it's been said, it was said at the beginning of this case, the defense doesn't need to call any witnesses. The defense doesn't need to say a word. And if the state does not carry its burden of proof, the only correct legal answer is not guilty. Right from the beginning, right from the outset of when this case was initially investigated, and then the nearly 3 years that followed, this has been a process whereby the investigators and those prosecuting this case have had horse blinds on and are looking at one man only. And we've seen the process. That's why there was such careful examination, cross-examination, getting into the details of all of these events, including electronic evidence and everything else, all the surrounding circumstances, many, many witnesses in this case, because there was a fashioning of how this investigation was going to go. And I'll get into that a little bit later. Missed opportunities, things that are frankly shocking that they weren't looked into. Let's talk a little bit more about the overall background here. And what we do know from the evidence, this comes as no surprise, there's nothing disputed about this. Zachariah and Sadie were in a very long-term relationship that lasted many years. Together, they share 3 children. This was not a perfect relationship, not one made in heaven. And as you heard, there were ups, there were downs, there were a lot of things that are part of a normal relationship. And every relationship has its own dynamics. Over time, there had been periods of time when they were together, then they weren't, then they were doing other things, but they always remained part of each other's lives because naturally they shared children in common. One of the things they talk about often are making plans so that Zach could help Sadie, Sadie could help Zach in these situations where they each had other things to do and they wanted to see their children and remain part of their lives. Now, over the years, we get to a point where, as Sadie testified, she was starting to develop a relationship with Rosalio. And this, again, as you heard, was they met on a Facebook dating site. They had started kind of talking. They had met. But this was at the very early stages of a relationship. It had only gone for a few weeks by the time all this happened. And as time progressed, we come to what I have to agree appears to be a tragedy here. Nobody knows where Rosalio Gutierrez is. Nobody knows what happened to Rosalio Gutierrez. And when we hear his mother talk about how she misses him and his friends that have not heard from him, I understand that pain. I understand that anguish. There's a big question mark up in the air about what has happened here. But all of this evidence, if you want to even call it that, all the facts that have come in, as we analyze them piece by piece, we're going to see that this is not a case where the facts themselves, the evidence itself, establishes in any way that Mr. Anderson is guilty. I want to start off by talking about stalking, because that's actually more complicated than the other 2 charges, because as we know, there's 2 counts of stalking. One alleging that Mr. Anderson was stalking Rosalio Gutierrez, and another count that he was stalking Sadie Beecham. There's a count of intentional homicide and hiding a corpse. And we all know what intentional homicide means. The instructions are very clear. It means the allegation is that there was an intentional killing of another person with the intent to kill him. And then hiding a corpse is very obvious as well. There has to be a corpse, and then there has to be an effort to remove it, hide it, to avoid prosecution, detection, etc. Fairly straightforward. Stalking is one of these weird laws where there's so many different ways that it can be shown. And you have to consider, as we have said, and we've talked about here, a pattern of conduct, things that connected together form an effort to basically cause somebody to have serious emotional distress, not just annoyance, not just why are you bothering me, or can't you just please go away. It has to be serious emotional distress and or fear of injury or death. That's stalking, okay? It's not just problems in a relationship that we might normally expect to see, especially when there's a dispute going on about who's going to have custody of the kids. And leading up to this, as Sadie talked about, there had been a discussion, an argument really, about what the status of the custody of the kids was going to be going forward. In fact, it had reached a head sometime shortly before this. And I know that Mr. Grayley would like.
One of the things I wish would have been pointed out. Yeah, please press that like button if you haven't subscribed yet. Please subscribe. If you are subscribed, check if you're still subscribed, because sometimes YouTube just removes people from subscribing, and that you press that bell button. But yeah, one thing that I wish he would have pointed out more, which I would have again hammered, Sadie abandoned the kids to go drinking. And after that, Zach started investigating what the actual F is going on. Perfectly normal. And if you go ask a divorce attorney, one thing that they will probably give as advice, but this is not legal advice. I'm just saying that many divorce attorneys will tell, gather evidence before a custody battle. And that, I believe, is proven in this case. Zach was gathering evidence to get ahead in a custody battle. But a dead guy. She went on a drinking spree in Mexico, and the best friend was one of the babysitters. She went away for a week drinking in Mexico, John. She had the option to go when she didn't have the kids. She had the option of, hey, Zach, can you hold the kids for a week? I'm on vacation. No. She went drinking. She left. She told her best friend, hey, come watch the kids. I'm going drinking. The vacation wasn't planned. It was more or less a spur of the moment. I need to go to Mexico and get drunk. And then she told her best friend, among others, to go watch my kids, please. Make sure they go to school. Her 12-year-old daughter at the time, I believe the twins were 4 or 5. Of course, everybody needs to needs to blow off some steam if you have kids, but you don't go on a week drinking binge in Mexico. You go for a weekend at most, and you can go on the weekend when Zach had the kids. And she specifically said to her best friend and others, don't tell Zach. She always had the option to go when Zach had the kids. She had the option to, hey, Zach, please watch the kids. She actively chose not to. On a regular school week, she went drinking in Mexico. That's not just, oh, let's have a vacation. Not to me, at least.
Like you to believe that all of these efforts that Mr. Anderson was engaging in was in order to have this masterful, intricately laid out plan of murder. But another way, and a more reasonable way of looking at that, is this is a man who has 3 children with Sadie B.
Yeah. It was her testimony. She went drinking in Mexico. Ooh, look at that. Thank you so much, EK from MN. $20 super chat is extremely rewarding to me. Sending only positive thoughts for tomorrow's sentencing. Thank you, Nicholas, for bringing awareness to this case. We are all in Zachariah's corner. Yeah. I have been in Zachariah's corner for quite some time, and I have to bring this up as well while we are at it. Anonymous donor on Zachariah Anderson's Give Send Go. You have the link to it on the top of the chat. It's pinned there. Anonymous donor, $50 in honor of Niklas drinking $7 whiskey for Papa Starow's birthday. Free Zachariah Anderson. I'm so thankful to you, anonymous donor. And I can go down here. It's me, Josie. $50. And EM English, $100. So that would be this week another $200 to Zachariah Anderson's defense fund. Now they have a lot. They have some. Gathering money for an appeal is not cheap. So please consider, instead of giving me 5 or something, send it, if you can, send it to Zach. Let's. Oh. How do we know it was a drinking bitch? She said it. Zach was hooking up regularly with a meth head with 3 felony conviction. That was not in evidence. Nothing. That last sentence of yours, never in evidence. Yeah, she was horrible on the stand. His hookup, never in evidence. Should he be shamed for that? Sure. If it was in evidence, I would have shamed the living F out of him for it. But now, this was before. This was in evidence. Sadie went to Mexico drinking for a week while she had custody over the children. She left them in the hands of the best friend. Why? Doesn't the best friend have a work to go to? Have other obligations? No. Here, take my kids. I need to go drinking. Sure, it's harsh, but I have 4 sisters and a baby brother. I have a combined 14 nieces and nephews. If either of them went drinking and leaving the kids somewhere, I would whoop their ass. That's not good parenting. I don't care the circumstances. You don't abandon your kids. You don't go drinking for a week without and leave your kids in the hands, even if she is my best friend. The best friend have a friend over. Does she know him? No. Oh, harsh about Zach's girlfriend. Okay, yeah. Well, we don't know if she's a meth head, but she did act really strange on the stand. She was more or less falling asleep, which speaks against meth, maybe other things. Maybe she was... damn, I'm going on the stand. I need 2 Valiums. I don't know. Sadie was on the stand testifying to going drinking in Mexico. Zach added the whoring. He said it 2 hours after someone told him Sadie went to Mexico to go drinking. He went over to check if the kids were all right. He fed them. He made sure they went to school. That's a responsible parent, in my opinion. And you have something called parental alienation. That's quite common when it is common in custody battles. So that is also speculatively something Sadie did to go move ahead in a future custody battle. Everything in Zachariah Anderson's case screams custody battles. The only difference is one guy ended up dead. A guy who owed money, who was actively trying to get laid with other women besides Sadie. Sadie seems to be the only one in that group who actually thought she had a relationship with Junior. So, but that wasn't in evidence. Yeah, it was in evidence. He actively tried to hook up with the witness who got lost on the way there. He actively tried to hook up with another woman. So, as what we know, he had 3 women. But he was juggling 3 women, at least, that we know of. And this was in evidence. Late, sorry, no notification. Yeah, YouTube is getting real horrible with the notifications. But thank you for showing up. Let's continue.
Beecham. He knows that they are not together at this point, and he knows that she is seeing other people, and they talked about it. And by the way, I think about 25 times Mr. Gravely say, if somebody's out there saying, I'm not jealous, I don't care, how can you believe that? Well, the testimony was, and you heard some of the recordings, that Mr. Anderson was honest about his feelings for Sadie, and he did admit that he had jealousy. He said that, yes, I admit it. And he was
Over 2 hours before my first boomer moment. I see that as a win. Normally, it's in the first 20. Where was I? Yeah, one thing that I'm really a bit furious about is that this Denny motion, that they couldn't implicate one of the witnesses. Let's not name him. And a witness was one of the guys who went over to Zach, who trespassed on his property, who had been seen with a rug that roughly matched the description of the missing rug, who Junior himself said, I'm going to meet with this guy on the day the prosecution alleged that the killing occurred. A guy who on the stand testified that Junior repeatedly owed him money. An F-bomb just got dropped. Yeah. Yeah. And this stalker business, he is going to get into it. Neither Sadie nor Junior was afraid of Zach. Junior, according to testimony, according to texts, said, I might go over there to break his legs. Sadie, in text, ended with XOXO, hugs and kisses. He stayed the night. Let's say this. She was not afraid of him, not for 1 second. The $60 was mentioned. It was not in evidence. And the same best friend on the stand, the same best friend who was seen with the roughly matched rug missing from the apartment, said he was repeatedly owed money. And they had serious arguments every time Junior owed him money. Yeah. Do we really think his best friend killed him over $60? There are a lot of killings done in the United States and worldwide for way less money. And you don't have to prove he actually did it. You only need to say he had the opportunity, he had the motive. And according to testimony, he met with Junior that night. But someone who knows this case much better than I do is here. Brother from another mother. Hello.
Hi, Nicholas. How are you?
Solomon and hi. Good to see you. Yeah, this stream has been going on for a bit longer than I suspect. I believe I told you on Twitter that we might talk about this other case for roughly 30 minutes. It became 2 hours. So, yeah. Good to see you. Well,
Good to see you too.
Yeah. Well, we are watching the closing arguments from Zach's defense team. I still believe that's a good defense closing argument. I would have hammered other points, maybe much harder. I would have been much rougher on Sadie, but I don't know why he chose not to, but that's not up to me. And since I don't have a stake in the game, I can say these things, that I would have hammered that. Yeah. Oh, how are you doing? Sentencing tomorrow.
Doing all right. Yep.
Yeah.
Getting ready for going to speak before the judge and weighing my words. It's just trying to make sure that I don't cross the line. It's going to be a precarious situation. I need to be able to speak to the judge and hopefully appeal to him without completely rubbing him the wrong way. And that's it's going to be a tough, a taut line to walk, I think.
Yeah, I wish I could advise you on anything, but I really can't. I'm not a U.S. lawyer. I have never been in that situation where I have to advise someone. I'm not a religious man by any means of the word, but I will pray for you tomorrow.
Thank you. Appreciate it. I mean, Jen and I have been bouncing some ideas off of each other, and I think that I've got an idea of what I want to say. I have the outline of exactly what I want to say, and then it's just trying to edit for runtime, because I only have so much time to say what I need to say in the courtroom. So I got to try and make it count, if you know what I mean. So, so we'll see. But it was a beautiful day. I finally had a chance to actually mow the grass and catch up on some of the yard work, which I'm sure that you're familiar with. It's that time of year. So I missed your tweet while I was busy doing all the other stuff.
Yeah, I really need to cut the grass while I still can do it with a lawnmower and not with scythe.
I was going to say, with a brush hog, you're going to go through with the tractor.
No, I have this small drivable lawnmower, which is really great because I can have a beer on it, I can have a cigar on it, and then I have roughly 5,000 square meters. That is times 15,000 square feet of lawn to mow.
Sure.
So yeah,
that's nice. In the United States, if you drive your lawn tractor with a beer, you can get busted for an OWI.
Private property. Well, if I drive it on the road, but since I have a farm, it's a different regulations. They really can't go into my farm and tell me you can drive here, and I can say you're not allowed in here. You don't have probable cause. You don't see the beer.
Yeah. Interesting. Oh.
And let's see here. I saw this. Erin Kruger, EK from MN, another $50. So that's $100 today during this stream to Zachariah's Defense Fund. So that put us to exactly 11,000.
Yeah, another milestone.
But it's a long way to go.
A nearly soul-crushing amount of distance yet. You know, we're trying to figure out exactly what it's going to cost to get the transcripts from all the court records, because we need to get the transcripts from all the hearings pre-trial. We need to get the trial transcripts. We need to get transcripts from the civil court case and things like that. And every single one of those is going to be a dollar sign. So in order to get those, we need to try and gauge what that's going to cost from the court, and that's part of the costs that this fund is providing. So for all the things necessary to try and represent Zach for his appeal, we're just trying to weigh and prioritize what that money needs to go to. So that $53,000 is a relatively arbitrary number, but because of course it's
you're breaking up. You're breaking up a bit. You're breaking up a bit. Yeah. Yeah, I know.
It doesn't even count the appellate lawyer, so it's a lot.
It's what do you call it? It's a number that gets you somewhere at least. And but every cent is valued, and I hope my chat will continue to give to the. And I do know that during sentencing tomorrow, David and Jeff will do streams. So I do believe something will come out of that. I really hope so, because Jeff's chat is much larger than mine. So I really hope that will make a big dent. And if it doesn't, I will refuse to drink on his Fuck It Fridays.
Well, Jeff said that he's gonna do a little griftathon for us, I know, and then he and I were going to get together on Wednesday, I believe, and do a little stream. We're going to talk about kind of the aftershock, the breakdown after sentencing, and it's I don't know, it's its own animal. We're trying to brace ourselves. Our expectation is that the judge is going to throw 60 years, give or take, at Zach, just so everybody out there is aware of like the number that's probably coming. It's a fine box sentence, and those are mandatory minimums, and that's just the unfortunate reality, because there's repeater charges, and that adds time, and mandatory minimums with every charge that they gave. And now the judge can allow him to serve those sentences instead of simultaneously, as opposed to consecutively, but that doesn't mean that he will. So we're just bracing ourselves for the worst and hoping for the best.
I made sure to be off on Thursday, so if I choose to go on Jeff's stream or David's stream, I can tell I will do $100 shots if they support the Zachariah Anderson Defense Fund.
What you're willing to put your body through for us, Nicholas. Thank you so much.
Hey, I've survived a lot of things in my life, but I hope I will survive Wednesday. But
Yeah.
Let's see here. You are currently. If I do $100 shots, that means I could be on I'm only 430 shots from $54,000. So it could be really dangerous. But hey, no, that's a bit. Maybe I should do a 1K for every 1K, something like that. Yeah, something. I will probably drink either way because the sentencing has been, and I've seen in the. I don't know Schroeder how he's known, but I've seen in the chat that he's known for hard on civil liberties, but I haven't seen that since he moved the goalposts in order to move the goalposts in order to move the goalposts. And that is horrifying. So the civil liberties he is known for, that, in my opinion, those went out the window during this trial.
I thought that was actually pretty interesting. Is that, from my understanding, Schrader was known to be a little bit more of a constitutionalist. You know, he had a reputation for wanting to uphold and stick to the Constitution, but I didn't really see that in this trial at all. It really seemed like he was just willing to let whatever happen. Like it was his send off, you know, as a judge, and he was willing to loosen his tie, if you will.
Mm. Yeah, and I know we've spoken about this before, that he might have his alternate motive might have been, before he retires, he needs to have a president in his name.
Mm-hmm.
And gift you all a mic for your computer. I just bought this before the sound was even worse.
I mean, I have a headset, but I didn't want to put on like a gamer headset, you know, and do that thing. And I don't have it hooked up to my laptop. So, I mean, I can try and project my voice. It's loud enough, I promise.
Yeah. And my ears get sweaty in this. I keep altering the headset around. But at least my voice gets heard. What see, he gets lost in the DA word salad. BS. Well, Gravely is the top dog in the prosecution, and so he's been in front of Schroeder, I believe, a lot of times, because he was elected in 2016. So this is at least 7 years of prosecutions where he had the opportunity to go in front of Judge Schroeder. So
I believe he was part of the Kenosha DA's office even before he was elected as the DA, but I don't know what his tenure is total in Kenosha. So he had plenty of years to be able to build a relationship with the judge.
Yeah, I did a stream about another judge in Kenosha who recently was scolded for the second time for what was it? Denying due process for a second time, and is still on the bench. So this seems to be an ongoing issue in Kenosha County, with judges and prosecutors not really caring about due process. So, and I will keep on it.
I mean, I think that it was pretty evident between the Rittenhouse case and my brother's case that the Kenosha County DA's office believes that someone exercising their right to silence means that they're guilty of an accused crime. You know, that was something that Binger had said. He actually was yelled at by Schrader for violating Rittenhouse's Fifth Amendment right, and then Gravely very snakily asked for permission to do it, and then in his closing arguments he even referenced my brother's silence as a quote unquote as an opportunity to clear up the record for himself. And for me as a citizen, that's problematic.
Just saw Kenosha, like he's from there or something. Well, almost. For you who doesn't know it, where I grew up is roughly 40 minutes away from a city with 100,000 inhabitants. You can go out there multiple ways. I even showed rough calculations about how to get to where I grew up. And it's a semi-wealthy area with interesting habits in brewing your own alcohol. And so there are so much similarities. And I jokingly say that I'm a Swedish redneck. And well, I'm not saying the Anderson families are rednecks, but you kind of are, aren't you?
I mean, we're country folk. My great grandfather was a farmer. He had 40 head of dairy cattle. When I was a boy, I picked stones and stacked hay and worked in the fields. Like that was normal for us. That we're it's not like we're idiots, but we grew up in the country. That's how it is.
Yeah. But being redneck is not about being not smart. It's just the circumstances. You mow your lawn and you find a car stuff.
Well, not quite that
bad. And not really, your family tree does not fork or nothing like that. But growing up in the country, we have another mentality, sort of, and kind of recognize each other from afar. Yeah.
There's just people that grow up in the country have country folk sensibility, right? This sense of community and sense of independence, right? Like this, because you rely on your neighbors, and it's a different way of growing up, or a different way of communicating, or just being connected with other people. Because as it turns out, when you get 2 feet of snow and you're digging yourself out and your neighbor's got the plow and they come through, you help them shovel, they help you plow, and you just take care of each other. That's how it works.
Yeah. With my tractor, this one, I do have a blade for it. And if we get snow here in the south of Sweden, blade comes on, and I plow the entirety of the gravel road, because I can't just. It's unnatural to not plow the entirety.
Right. The type of person that pulls their neighbor out of the ditch, that when somebody is stranded on the side of the road, you check on them. That's how we grew up. Just like simple, honest folk, just like that.
Yeah. Let's see here. I had to say, Peace Pony became a member. Thank you so much for becoming a member. Much appreciated. And if you can choose between Super Chat and being a member, please be a member. If you need something to say to me, I have the page up for Zachariah Anderson's defense. Oh, look at that. Let's bump. Brittany Arons, $50 again. One day closer to freedom. Yeah, that's the mentality. You have to prepare for the worst, but you still have to see because sadly Zach is convicted. That's the reality now. He is found guilty. That's the reality. But if you kind of get into the mindset, now we are working towards his freedom again. and it's really hard, and I don't wish it upon my worst enemy to ever be in that situation. And as I said in previous streams, I've known people like Zach, like Solomon, like Sinet, like Sadie, bunch of people in a small community near a larger community, and there are custody battles. I've seen it all already. Not in this circumstance that one guy ends up dead. But it wouldn't surprise me if it happened either, because crap happens. What is surprising is the absolute lack of evidence. And I have a critic in the chat, and I love it because he challenges my my logic. But also I see that he gets some of the evidence wrong. For instance, the needle pin speck. And I say it, if that is all that is, after supposedly getting 270-pound Junior inside a rolled up bloody rug without leaving a trace from the apartment to more, it's a minivan, it's a family van. It's not a work van, it's a family van converted into a work van. And all that is a needle pin speck of something they can't even say is blood. And that's not evidence for me. That's, yeah, I'm still furious about that. And
I mean,
that might be,
I mean, that's the problem is Go ahead.
Yeah, that's one criticism I have of the defense, that they didn't point out enough how the different ways that spec could have gotten there. They pointed out that Junior said, I might go over there to break Zach's legs. He had the means, he has the opportunity. Those two friends who went over there to threaten Zach, well, they went from the apartment to Zach. Okay, they testified they were nowhere near the van. I don't care. Why wouldn't they lie? And then you have the cop or cops who went directly from the apartment to investigate the van. There are too many opportunities for that needle. And as I said previously, if Junior went over there, heavy smoker, smoker's cough. Ta-da! Yeah. There are
realistically, it could have been the same brownish red substance that was all over the rest of the van. And it just happened to be that maybe he touched the van in the same spot as that one little speck, that one little fleck. And we don't know, right? Because Sadie had put him up to going over to my brother's house to harass my brother. And it, unfortunately, maybe Sadie does know if he did. They had a 3-hour Skype conversation in the middle of the night, the same night that Mr. Gutierrez's phone had pinged at my brother's home. So it just, I don't know that he didn't go to my brother's home. And I don't know, frankly, that the transfer DNA didn't come from Sadie herself. She was literally at Rosalio's, home on the night of the 16th, and then picked up the kids, from my brother on the afternoon of the 17th. For all I know, she had, Gutierrez's DNA on her hands or on her clothing, and then touched the inside of the van.
Yeah, but that's the definition of transfer DNA. Someone touches and then touches something else. And it's been cases in the United States where that has been brought into evidence as that speck or whatever it is of touch DNA is so small, you can't exclude it was transfer DNA.
Right.
And
let's not rule out the fact that there could have been a mistake at the crime lab. It was such a small specimen that it wouldn't have taken much to contaminate it, with just a technician error. And I mean, those things happen. Errors happen. Human errors happen, which is why we're supposed to be able to retest the DNA and to verify it, but they couldn't do that with this single specimen, which is alarming and problematic.
Yeah, because if any evidence, if it can't be retested by the defense, it shouldn't be allowed, in my opinion. But here it was. And that I had a stream, well, Solomon knows this, I had a stream with Steve Gosney, where I showed him first a baseline of how DNA evidence is collected, presented in trial. And he hadn't seen the expert testimony in Zach's case. And after I showed him, well, you were in the chat and saw it. You saw his reaction. Steve Gosney is an experienced trial attorney, appellate trial attorney. And the look on his face when I said to him, that's it. That's the entirety of the DNA evidence presented in court. And I believe his immediate thought was, but that's prosecutional misconduct. You don't present stuff that way, as you don't have the authority as an expert witness to present DNA evidence as an opinion. It should be presented as a fact and nothing else.
Yeah,
and
at the very least, an unethical presentation, I think, is where he went with that, because there's like a prosecutorial handbook on how to present DNA evidence and exactly what steps you're supposed to follow to then, present it to the court, and bravely didn't do that at all. It's like he didn't know what he was doing. I mean, to be fair, he just had learned what an argumentative question was. I believe that was the issue in the courtroom during this trial, after he claimed they had 31 years of experience as a lawyer, something like that. So I'm not really sure. Yeah,
and I do believe he said it was an appellatable issue, but I don't. That's one thing. I don't know the process in the United States of appellate issues and stuff. If they objected, I do believe they took it in cross. They questioned it at least, but I'm not sure if that still can be used as a procedural error. That's it.
Yeah. I mean, there are some things that you're supposed to object to preserve for appeal. I know that that's a thing. I didn't go to law school, so I don't know the nuance in that. But there are things that that can be brought into light that were not objected to, that could be still appealable issues. Because the appellate court doesn't argue the case again. They don't go back and argue the fact that that this DNA is not blood, right? Not necessarily. They might be able to have an argument on that, but I don't know that they can. And there's some issues with the presentation, a lot of the motions that occurred before the trial and things like that'll continue to also be appellate issues, and we'll get all the transcripts, all that stuff to wrap up with a nice tidy little bow and send into the appellate court, because we're arguing the execution of the law, and that's what you have to take to the appellate court.
Let's see from Wendy. Is the donated money in a trust? Well, at the moment, the donated money is at Gives and Go. Yeah. There. So at the moment, everything here is on the Gives and Go page. So it's not distributed yet. I'm not sure. I don't know how Gives and Go work, if you have to raise the actual money or if you can receive the money donated so far. I have no idea. The person who set this up should know it better. But I'm not sure how. Well, maybe you can go into that in some shape or form.
Currently, we haven't drawn on it at all. So it's all still sitting there waiting to be drawn off and utilized. We're setting up a way to handle it, so we don't take a hit on our taxes because we don't want it to be income for us. It's supposed to be a donation for a cause. So I'm working with my my CPA to figure out the best way possible to handle the money and make sure that it goes to the right place in the right way. So just because this is something that the federal government's not supposed to get their sticky fingers on, and we want to make sure that this all goes to Zach. Does that make sense?
Yeah, it makes sense. Gigi says the T-shirts and other merchandise is a fundraiser as well. Yes. There it is. I will. I can only pin one thing at a time, but I will pin that as well. There. And if it works somewhat as it does here in Sweden, you more or less, if you hire or if you get an appellate attorney, that money can go directly into directly to that attorney. But I'm not even an expert on taxes in Sweden, so I can't say how it will be in the United States. So I can't say boo or ba on that one.
Yeah,
but
I mean,
looking at how you have done so far, I would trust you with any cash, because the amount of time and money you have spent on Zach's defense so far tells me that, yeah, you are. Of course, you're doing the right thing. But as Jeff said in one of his streams, that the fact that he has a family standing up to him, standing with him in this, is probably the most valuable thing he can have. No matter how the appeal goes, he still has a family that will visit him and stuff like that. And one of the reasons I might do a video or stream on it later on, and I don't know if I should tell you because you might object to it.
To be fair, Nicholas, I've had a lot of people approach me in the Facebook group about what people are doing, what people are producing, what people are putting out there. I've respectfully asked everyone to remain cordial, to not attack the character of other people when discussing the case, to stick to the facts. Outside of that, I'm hoping that we at some point reach critical mass in this with people that really believe in our cause. That I'm not going to dictate what people do creatively. If people are going to do something, create something that is going to bring or garner attention to the case, by all means, go ahead. You know, I want to make sure that we're all on the same page, and that getting word out, recognizing the fact that the government has violated my brother's rights in this trial, they at the very least outwardly or overtly inferring that they're trying to get as close to violating his rights as possible, you know, and all of the issues that came up, it should terrify all of us as Americans that this case could become precedential, because if it's normalized that we're going to violate not one but two constitutional rights to try and get a guilty verdict, you know, who is safe in our society? Why do we have the rules as they stand? You know, if that's going to be the interpretation by the judges, it's not okay.
Yeah, but the video I have in mind is an appeal to OA with, once you're 18, don't watch this video until you're 18.
I heard the other day that she gave herself a tattoo, so she's starting young, Nicholas. It's not.
Well, when it comes to tattoos, I have no advice to give. I might have been in her age when I got my first one, so stuff happens. Yeah, and I know through what you have told, what Senate has told, and listening to her on the stand, she's a bit boneheaded, but I can relate to that. But
Stubborn.
that's
Yes.
stuff, yeah. And but that also has also a critical mass. I know I have it myself. Once you have you resist, you resist, you resist, you resist, you resist, but then poof. Okay. So that's why I'm having at least planned out in my head, don't watch the OA. I will not name her. I'm not a prosecutor. I'm not the judge. I will not name her. I will simply say, OA, don't watch this video until you're 18. And then I might line up a few things that because at 18, I consider people adults. And there are some things I can only speak to an adult. And then again, I don't want to be accused of, oh, you're talking to a minor. No, I'm talking to the 18-year-old OA.
She had watched. I believe there was a copy of the video that my brother had explained the "I love you" signs. I believe there's a video of that was circulated, and she had commented on it, and she had made the comment that she misses his voice. That had been 3 years since she had heard his voice, and she said that she had missed him, and that's stuff like that that's really painful to hear, or see.
And one thing that is really scary, that at least in Sweden, even if she would be to change her testimony, it wouldn't matter, sadly, because the jury was already told she had changed her story from the first interview to her testimony in the trial. So her changing her testimony, sadly, it won't matter, because the jury already confirmed that what she told at the trial, that was truth. But it doesn't hurt.
However, I mean, it can be presented if it's overturned and goes to mistrial. If it's retried, then
yes, with a new jury,
and then that whatever changes would be submitted to that jury would be factual. No, she is not over 18. She's 15.
No, yeah, and just listening to what other people have said about her, she probably is. If she's seen that video, I wouldn't be surprised if she actually scours the internet for information. I wouldn't be surprised, but I can't say for sure. But I just say that I will probably make a video sometime in the near future where, don't watch this until you're 18, and then
I mean, all you have to do is make it the adult, the sensitive content or whatever. Nobody ever lies about their age in order to watch those videos. So I think that you're clear there.
Yeah. Yeah, but I need to cover all the bases because I don't want to be accused. I will probably be. I've been accused of so many strange things through my life, so I'm quite accustomed to it. But yeah, she is very bright, and I might encourage her to go to law school, actually, because it's a good experience to have been in a trial, to have that experience. But I have not made that. I plan most of my things in my head, but this is. I'm not sure. You have to understand. She went through what was it, 40 hours of interrogation, and was then more or less threatened by legal issues if she didn't testify. That's hard on an adult. I can't imagine, however stubborn she is, 40 hours. And then the E.R. Gravely. Yeah. Yeah, but I do have certain words. Not everything might be positive, but definitely not all negative. But I do believe once she's 18, she needs to hear it. But I will try to be cordial. I know I'm not being especially cordial to Sadie, especially about the Mexico trip, but I have a large family, and as you might have heard, if any of my siblings would have done that, I would have smacked them around. You don't go drinking for a week when you have kids.
I mean,
I don't.
At the very least, I don't understand why Zach isn't the first person to talk to about that. It's bankrupt in so many ways. It was clearly manipulative. It was clearly set up. And the fact that Rebecca was the one that was there. Knowing Rebecca and how she has treated Zach and how she has worked to connive, to do these things, against him. It doesn't shock me that she was the one, and it doesn't shock me that she called the police when he showed up and smiled and said hello and then made breakfast for the children. None of that shocks me. None of it.
No, in a hypothetical scenario, if I found out that one of my sisters went on a binge and left the kids with a friend, I would have gone over there, thrown the friend out, and said, "Okay, I'm here. Let's get to school." I don't care who the friend is. If the best friend, I don't care. Even if I know it's the best, but who will she bring over?
Right.
I don't know. I'm not taking any fucking chances with kids.
Right.
That's
I mean, Wendy said it very well. The right of first refusal should go to the other parent. I understand that if Zach was not available, that you might be able to work together to find someone else to watch the kids. I'm not saying that Sadie should never have been able to take a vacation. I don't think that that's fair to her either. But the reality is that if you're going to go on a trip and you're going to do something like that, the very first person that needs to be involved in that plan is the other parent, and that it was manipulative, and manipulative and self-centered to try and play it any other way, and it's unfortunate that I think it should be evident to everybody that was paying attention that it was a dishonest play on her behalf to try and manipulate my brother.
Yeah, I agree. Yeah, I do believe there's so much to say about this, but I do believe that it's 1 o'clock here, so it's not that late for you, but it is sentencing tomorrow, and you will need every amount of rest that you possibly can. And
It's going to be a long day.
Yeah.
Did you make it all the way through the closing arguments? Did you get to the end?
No, I have. Dun, dun, dun. Oh.
See, I thought that Kirk was very rational and very technical. He's also the person that did the voir dire, to my understanding. So it was sort of like he opened it with the jury and whatever his questions were to them, he understood that their strengths and or weaknesses or what he was shooting for in the opening and closing arguments, or at least in the closing arguments, to try and leave an impression with them. My issue is that I don't think there wasn't enough fervor, right? Like there needed to be a bit more passion. Like what he did was very technical, but in his rational, calm, technical approach, it did not give the same air that Nicole had, having gone through the discovery, having having done this whole case, that she passionately believes in my brother's innocence because she knows he is. Right. So I think that there's an emotional disconnect, something that would have been very important for that jury to see, and that was I think my biggest issue that I saw.
Yeah, I agree, because he didn't do anything wrong per se, but as you said, there wasn't passion in it, and I think there's so. Oh, I have. Oh, it's an hour. There's an hour left of his closing, and that will be a bit too much because it's 1 a.m. here, and
Sure.
yeah. But thank you for showing up, and I will probably talk to you later. I don't know if I will go on Jeff's stream or David's stream or both. I might skip between them, but hopefully we can get more dollars into that defense, the gives and go, because you need every damn cent of it, and probably, as Jeff said, you need more. And I know that both you and Zenit has families, newborns, and so it will be really, really rough. But the most important thing you already have, and that's family. Even if it takes years before an appeal is even possible, he has family, and I think he values that more than the.
I've gotten him to laugh a number of times, even though the weight of the world seems to be on his shoulders. So, the chat, everybody out there in our group, all those supporters that have been writing him letters, it gives him something to focus on. That's not rehashing the trial. That's not rehashing the case. That's not obsessing over his innocence and how he's been wronged. So I just wanted to thank you all for putting yourselves out there, for reaching out to him. It helps his mental state a great deal. And thank you all for being here for us.
Yeah. Did you see my the tale of Prosecutor Scrooge?
I sure did. I actually retweeted it and shared it.
Yeah.
I couldn't anyone. Not a single prosecutor came to mind in reference to that story.
It's any resemblance to any prosecutor, living or past, is coincidental for legal reasons.
Yep, that's right.
There might be another video coming up named Prosecutor Pinocchio, but yeah.
A Pinocchio story, one where the more lies they tell, the larger their nose grows. I feel like that one should be told.
Yeah, it should, shouldn't it? Yeah. But I might wait until after sentencing, and yeah.
I can't think of a specific prosecutor.
No.
But
it's
I
very
like
general.
Out there.
Yeah, it's very general, and a few might. Oh, is he talking about? No, I'm definitely not. You can't prove I'm talking about you, huh?
Right.
And if you think it is me talking about you, come over to Sweden and sue me, you motherfucker.
It'll be a hard time to prove that one.
Yeah. Yeah. Well, that would be amazingly fun. Someone coming over here to sue me for defamation. Oh, I would grift the ever-living fuck out of that one.
I might consider flying to Sweden to attend the hearings, just for fun.
Start a YouTube channel and stream it.
I'm not allowed to start a YouTube channel unless Jen gets to sit in the background and complain about all the projects that I have not finished around the house. That's the ruling. So
Yeah, okay.
I don't know that that's going to happen until the house is the house she wants.
Yeah, I'm finishing a house. I've been renovating for 5 years here, and I have at least 2 more years. And then I'll probably have to start all over again. What can I say? But yeah, I will. Oh, did I miss that one? Julio! Did it seem like they were trying to make it confusing when they went through all the non-evidence with the sketchy lab woman? Yes.
Yeah.
Like where it even came from. The lab had. Oh, the lab has had scandals in the past. I will check that out, and it might be a video on it.
Yeah, I believe that that was connected to the Stephen Avery case.
Okay.
Yeah, so they had done an investigation of the crime lab that had processed the evidence from the Stephen Avery case and found a bunch of misconduct and a bunch of undisciplined issues in it. So there are some issues with, I don't know if it was this specific crime lab, but the crime labs here in the state of Wisconsin. So again, I don't want to throw mud at the people that testified in the court case. They have careers and families and lives unjustly, but it would be something that's worth looking into for sure.
I will look into that. But I believe we are over 3 hours in. You've been in here for 45 minutes. We have had a good discussion. The chat had to meet you. Had the enjoyment of meeting you again. I will watch Jeff's stream with you on Wednesday, and I pray that I will pray for all of you.
Thank you.
That maybe George Schroeder have had an interesting month before sentencing, where he might even have got his head checked out. But yeah, until next.
I'm gonna go finish writing my statement, ironing out the last couple of drafts with Jen, and we want to make sure that we're presentable for court tomorrow. So all that stuff needs to happen.
Yeah. Thank you so much for showing up, and thank you so much for the chat again for showing up. Thank you for the super chats. Thank you for being a member, and thank you for donating to Zachariah Anderson's Defense Fund. I hope you all have a nice Monday, and talk to you all later. Have a nice day.